in addition to already excluded subjects in List 2. Article 239AA3A confers legislative power to the NCTD. However, it does not confer legislative power to NCTD over all entries in List 2. Article 239AA3 provides multiple safeguards to ensure that the interest of the Union of India is preserved. First, Subclause A of Clause 3 removes 3 entries in List 2 from the legislative domain of NCTD. It provides that NCTD shall not have the power to enact laws on matters with respect to entries 1, 2, and 18 of the state list, and entries 64, 65, and 66 of that list insofar as they relate to the said entries 1, 2, and 18. Second, Subclause B of Clause 3 clarifies that Parliament has the power to legislate on any matter for a union territory, including on subjects with respect to which NCTD has legislative power under Article 239AA3A. In other words, Parliament has a plenary power to legislate on a subject in any of the 3 lists of the 7th schedule for NCTD. Third, it provides that where there is a repugnancy between a law enacted by the Legislative Assembly of NCTD and a law enacted by Parliament, the latter will prevail. The law enacted by the Legislative Assembly shall, to the extent of the repugnancy, be void. Unlike Article 254, which provides for the overriding power of Parliament only on subjects in the concurrent list, Parliament has overriding power in relation to the NCTD over subjects in both List 2 and List 3. Fourth, the second proviso to Article 239AAC provides that Parliament may enact at any time any law with respect to the same matter by including a law adding to, amending, varying, or repealing the law so made by the Legislative Assembly. Fifth, under 239AA7A, Parliament may by law make provisions for giving effect to or supplementing the provisions in the foregoing clauses of 239AA, and for all matters incidental and consequential thereto. The article stipulates that such law shall not be deemed to be an amendment of the Constitution for the purposes of Article 368, which deals with the power and procedure to amend the Constitution. Thus, Article 239AA3 balances between the interests of NCTD and the Union of India. Article 239AA expressly excludes entries 1, 2, and 18 of List 2 from the ambit of the legislative competence of the Legislative Assembly. 239AA also stipulates that the legislative power of NCTD is excluded with respect to entries 64, 65, and 66 of List 2, insofar as they relate to entries 1, 2, and 18. Entry 1 deals with public order, entry 2 deals with police, and entry 18 deals with land. When we explain the entries, thus, the exclusion of entries 64, 65, and 66 to the extent that it relates to entries 1, 2, and 18 from the legislative competence of NCTD indicates that the governance structure envisaged in Article 239AA for NCTD was only to exclude specific entries from its legislative competence. To read the phrase insofar as such matter is applicable to the Union territories as introducing an implied exclusion of the legislative powers of NCTD with respect to certain other entries would be contrary to the plain meaning of the provision. Article 239AA establishes the Legislative Assembly for NCTD. The seats in the Legislative Assembly are filled by a direct election from the constituencies of NCTD. The Legislative Assembly of NCTD embodies the constitutional principle of a representative democracy similar to the Legislative Assembly of the state. The members of the Legislative Assembly of the NCTD are selected by the electorate of Delhi to represent their interests. Article 239AA must be interpreted to further the principle of representative democracy. To interpret the phrase insofar as any such matter is applicable to Union territories in a restrictive manner would limit the legislative power of the elected members of the Assembly. The members of the Legislative Assembly have been chosen by the electorate to act in their stead. Thus, the legislative competence of NCTD must be interpreted to give full impetus to the will of the electorate. Then page 53. The principles of democracy and federalism are essential features of our constitution and form a part of the basic structure. Federalism in a multicultural, multi-religious, multi-ethnic, and multilinguistic country like India ensures the representation of diverse interests. It is a means to reconcile the desire of commonality along with the desire for autonomy and accommodate diverse needs in a pluralistic society. Recognizing regional aspirations strengthens the unity of the country and embodies the spirit of democracy. Thus, in any federal constitution, at a minimum, there is a dual polity. That is, two sets of government operate, one at the level of the national government and the second at the level of the regional federal units. These dual sets of government, elected by we the people in two separate electoral processes, is a dual manifestation of the public will. The priorities of these two sets of government, which manifest in a federal system, are not just bound to be different, but are intended to be different. While NCTD is not a full-fledged state, its legislative assembly is constitutionally entrusted with the power to legislate upon the subjects in the state and list and concurrent lists. It is not a state under the first schedule to the Constitution, yet it is conferred with power to legislate upon subjects in lists 2 and 3 to give effect to the aspirations of the people of NCTD. It has a democratically elected government which is accountable to the people of NCTD. Under the constitutional scheme, NCTD was given legislative power which, though limited in many aspects, is similar to states. In that sense, with the addition of Article 239AA, the Constitution created a federal model with the Union of India at the center and the NCTD at the regional level. This is the asymmetric federal model adopted for NCTD. While NCTD remains a union territory, the unique constitutional status conferred upon it makes it a federal entity for the purpose of understanding the relationship between the Union and the NCTD. A combined reading of Articles 73 and 162 of the Constitution indicates that the Union has exclusive executive power over entries in List 1. The states have exclusive executive power over entries in List 2. With respect to List 3, that is the concurrent list, the Union shall have executive power only if provided by the Constitution or by a law of Parliament. The states shall have executive power over the entries in List 3. However, if a central legislation or a provision of the Constitution confers executive power to the Union with respect to a List 3 subject, then the executive power of the state shall be subject to such law or provision. The executive power of the Union in a state over matters on which both states and the Union of India can legislate, that is the concurrent list, is limited to ensure that the governance of the states is not taken over by the Union. This would completely abrogate the federal system of governance and the principle of representative democracy. It is with this objective in mind that the members of the Constituent Assembly thought it fit to limit the executive power of the Union in a state over matters on which the state legislature also has legislative competence. The principle in Articles 73 and 162 would equally apply to the scope of executive power over matters which are within the legislative competence of both the Union and the GNCTD. This is because the objective of the provisions is to limit the executive power of the Union in the territorial limits where there is an elected government of a federal unit. Both Parliament and the legislature of NCTD have legislative competence over List 2 and List 3. For the purposes of NCTD, both List 2 and List 3 are concurrent lists. Thus, the delimitation of executive power between Parliament and the government of NCTD with respect to entries in List 2 and List 3 are guided by these principles. Both Parliament and the legislature of the NCTD have the power to enact laws with respect to List 2, subject to the caveat that entries 1, 2, and 18, and entries 64, 65, and 66, inasmuch as they relate to entries 1, 2, and 18, are carved out of the domain of the Legislative Assembly of GNCTD and List 3. The executive power of NCTD shall extend to all entries in List 2 and List 3, other than those entries which are expressly excluded in Article 239AA3. Such power shall be subject to the executive power of the Union through the Lieutenant Governor only when the Union has been granted such power by the Constitution or a law of Parliament. Therefore, the executive power of NCTD in the absence of a law by Parliament shall extend to all subjects on which it has power to legislate. It was held
So that is, of course, the Chief Justice of India reading out the unanimous verdict as far as the Delhi government versus LG war is concerned. Let's go across to our reporters who are in fact tracking all those developments, can probably break down the legalese for us. Nalini, what do you understand from so far in terms of what the CJI has said?
Well, Polemy, the CGI is essentially talking about the extent of powers that both the center as well as the Delhi government have when it comes to the control of the national capital. Now, what the Supreme Court is elaborating at this point is that Delhi has acquired a special status due to the fact that it is the capital of India, which means that it is governed and controlled both by the Delhi government as well as the central government. And at the same time, the important aspect that the Supreme Court is highlighting is that both of these are democratically elected governments, so they are answerable to the people of Delhi at the end of the day. That's precisely what the CJI has said, is that democratically elected governments are answerable to the people of Delhi. But at the same time, they're also going into the constitutional aspects about how the center has control over three specific aspects, which are land, law and order, which includes the police, as well as the law and order, land and police. That center has exclusive control over when it comes to the national capital. But in all other aspects, it is the Delhi government that has the power to legislate and administrate the laws that are pertaining to how the capital should function. So in pursuance to that, what the CGI is saying is that it's a federal structure, and all of these issues that are arising out of the fact that it's a dual control in the national capital. What the Supreme Court said right now is that the real power of administration must reside in the elected arm of the state. So although the Supreme Court has clarified is that if there is a clash between a central law and a state law, the central law will prevail. But at the same time, they are saying that the real power of administration must reside in the elected arm of the state, which is a very important breaking coming in from the Supreme Court. They've also said that the term administration can't be understood as entire administration of the Delhi government. Otherwise, the purpose of the democratically elected government in the state will be diluted. So it seems that the Delhi government's powers regarding the control over Delhi are being elaborated on by the Supreme Court, where they are saying that it's a democratically elected government and the powers of the state government cannot be diluted despite the fact that it is a national capital. The Supreme Court is also saying that the principle underlying the chain of governance will be diluted if the powers of the Delhi government are allowed to be diluted. The administration cannot be understood as the entire administration of the GNCTD. Otherwise, the power of the elected government will be diluted.
Right.
Big breaking news coming in, follow me right now, is that the Supreme Court has said that there is a principle of collective responsibility which includes the officers, and if the officers feel that they are insulated, it will affect their performance. The officers being spoken about are the civil servants over who the center and the Delhi government have been fighting over, the control of which have been fighting over in the Supreme Court. The pronouncement is underway, and any time now we can expect exactly which way the verdict is going.
Okay, Anisha is bringing us that big breaking news. At the moment, the Supreme Court has said principle of collective responsibility includes officers. If officers feel they are insulated, it will affect performance. Anisha Mathur is joining us live at the moment. Anisha, break that down for us. That's a big piece of breaking information that you're bringing to our viewers at the moment.
Well, breaking news here, Polemy, the big order from the court that GNCTD ought to have control over services except for the subjects which are expressly excluded, which means that apart from land, police and law and order, GNCTD ought to have control of services. It's a big win for the Aam Aadmi Party government, which is being read out by the Supreme Court right now. However, there are certain clarifications that are being made by the court that public order, police and land, the services that are there will be excluded from the Delhi government, but the Indian administrative services required for the administration of policies, day-to-day administration of the region will lie with the NCTD. I'm bringing you
Anisha, just break. Yes, absolutely. Anisha, just simplify that for us. Does this mean that the Delhi government, the elected government of Delhi, will have control over the transfers and the postings of civil servants?
Well, the Supreme Court, Polemy, as I speak, is still reading out the verdict in this particular judgment. It is very, very crucial that what the court has said, that we reiterate that in the light of Article 2000 AA and the 2018 Constitutional Bench judgment, the LG is bound by the aid and advice of the Council of Ministers, which is the elected government of the NCTD, in subjects which are within the state list and the concurrent list. To simply put, it means that outside of public order, police and land, the LG has to listen to and work with the aid and advice of the elected government of Delhi, which is a big win today for the government of Delhi, because the court has specifically said that day-to-day administrative services will be under the control of the elected government. And as I said, Paulami, the Chief Justice is still speaking. What the court is saying is that in view of the discussion, our conclusion is that there is no homogeneous class of union territories in India. NCTD is not similar to other union territories. It has been given a specific separate class. NCTD has been given a class apart from other union territories under the constitution itself. The legislative assembly of the government of Delhi, of the elected government in Delhi, the legislative assembly does have the power to pass laws under list 2 and list 3, which also means that the executive government, that is the elected government of Delhi, does have the power to control all the subjects under list 2 and list 3, except for those where their law is clashing with the laws passed by the centre. What the court is
Anisha, just hold on. Just hold on for a moment. We will, of course, soon get a reaction from the Aam Aadmi Party. We believe that Saurabh Bhardwaj will be speaking soon. But quickly, Nalini, coming across to you. Just cut through the clutter for us. Give us the headline.
Well, Paulami, it is a win for the Delhi government at this point, because what the Supreme Court has said, that except for the 3 exceptions that are already mentioned in the constitution that come under the exclusive control of the centre, which are land, public order and police, except for these 3 criterias, all other aspects regarding the control of administrative services will be under the Delhi government. So it's a judgment essentially in favor of the Delhi government, except for the 3 aspects that are already in control of the centre. So that's what the Supreme Court said. And the main reason behind that is that the Supreme Court said that the state government is a democratically elected government. Yes, Delhi does have a special status of dual authority, but at the same time, the powers of a democratically elected government cannot be diluted. And if these powers are not handed over to the Delhi government to run the administrative services in the state, except for those sections where the centre has exclusive power, then the power of the Delhi government will be diluted. The principle of collective responsibility, which means that the Delhi government and the centre have to work together in tandem with each other to make sure that the Delhi continues to function on a day-to-day basis, that will be diluted. The principle of collective responsibility will be diluted, and the officers, the powers of the officers in itself will be diluted if everything is under the control of the centre. So it's a big win coming in for the Delhi government. This is what they've been hoping for a long time, ever since they challenged a 2015 notification before the Supreme Court stating that Delhi government should have exclusive powers over the control of the civil servants. Now the Supreme Court categorically come out and said that the Delhi government will be allowed to do that. At the same time, they've also reiterated the fact that it is the duty of the Lieutenant Governor to work on the aid and advice of the Council of Ministers, which means that the Lieutenant Governor himself cannot continue to work in isolation and not take the advice of the Chief Minister and the Council of Ministers when it comes to the day-to-day administrative issues regarding the national capital.
So that's a big, big win for the Aam Aadmi Party Delhi government in the Supreme Court. The Supreme Court has said the LG is bound by the aid and advice of the Council of Ministers in matters in NCTD's legislative governance. LG will be bound on GNCTD decision on services. Ashutosh, coming across to you right now. Big win for the Aam Aadmi Party. Any word that you're getting in from the party at the moment? What's the first reaction?
Well, there is in fact a discussion already underway. Of course, Chief Minister is also watching this verdict. What the decision and what the party believes, that perhaps almost more than 8 years, the powers of an elected government was almost kept under arrest. And this is perhaps after the Supreme Court verdict, the status quo of the elected government has been restored in Delhi. Remember, May 2015. by the Ministry of Home Affairs, which took away the ACB as well as services powers. And ever since, this was only the battle. First, it went to 3 judges bench in the Supreme Court. And now finally the Constitution bench, all it says, the fundamental principle of the governance, that elected government must take decision. Remember, when it comes to land, public order and the police, there have not been ever any dispute between Delhi and centre, because the Delhi government was quite clear about these constitutional arrangements. But when it comes to the services, including the transfer and posting of the contention from day one, from the street, from assembly to the Supreme Court, have been made only that it is the right of the elected government, that they have got the policy maker, they have to implement the promises that they've made to public, and for that it is necessary that officers must take the decisions.
So hold on with us, because this is of course a big day at the Supreme Court. It's a mega day for Maharashtra politics as well. Next up is that judgment in the Shiv Sena internal rift matter. The Constitution bench led by Chief Justice of India D.Y. Chandrachud is already in fact pronouncing its verdict in the matter. This is what we're hearing from our legal reporters who are tracking this extremely closely at the moment. A big decision over there. Big and important. This is, remember that they are in fact looking into various legal and constitutional angles as far as this judgment is concerned. Already what they're saying is that the Maharashtra issue is to go to a larger bench. Decision in the Nabam Rebia case is to go before a larger bench. It merits reference to a larger bench. Remember, this is something that the Uddhav Thackeray faction had challenged, that basically that 2016 order in the Nabam Rebia case, which is the Arunachal Pradesh case, had basically stated that the speaker cannot proceed forward with any sort of disqualification proceedings if there was a no confidence motion against the speaker himself or herself. Anisha, if you're with us, can you break down what's happening in court at the moment?
Well, Paulami, a very big decision legally as well as politically, as the Supreme Court refers the issue now to a larger bench. What is, however, important is that the court has noted that there seems to be an issue where the provisions currently are being misused by MLAs. Therefore, the court has said that the Maharashtra issue of whether the speaker had the power to rule on the disqualification applications, what was the power of the government, governor, etc., will have to go to a larger bench. Whether this where there is a disqualification matter pending, what will be the powers of the MLAs, what kind of actions
Anisha, just to interrupt you over there, I apologize, just to understand this, to simplify this, when the court says provisions are being misused by MLAs, this we're talking about the 2016 Nabam Rebia judgment, this means this is a win for the Uddhav Thackeray faction.
As I said, the Chief Justice is still reading out the verdict. The observations of the court, of course, politically it will be considered a win for the Uddhav Thackeray government, but because they get a moral victory here, because the court is saying that this kind of a vagueness that is there, the questions that are left open have allowed the MLAs to misuse. However, we must remember that legally the court has not made any verdict as far as the merits of the case are concerned. What is also important, as one more important point is, Paulami, that while the Nabam Rebia matter has been sent to a larger bench, the court is passing orders on the merits of this particular case, which is something that is going to be a very, very crucial to see. What exactly is the court saying in this matter? Maharashtra matter, Nabam Rebia will go to a larger bench, but in Maharashtra what has happened? The Chief Justice is making certain observations on the merits of the matter. He is saying that the political party which reaches the halfway mark forms the government, and a coalition of political parties may form the government. He's looking into the legal aspects of this entire issue of what has happened in Maharashtra. Let me just clarify one more time. Nabam Rebia case has gone to a larger bench with regard to the powers of the speakers, etc. But as far as Maharashtra itself is concerned, what has happened on merits, whether whether the trust vote could have happened, whether the disqualification proceeding could have happened. On that, the court is pronouncing its verdict, and on the merits of the matter, the court, even as we speak, Polemy, the Chief Justice, is still reading out his verdict at this moment, and we will be able to tell you shortly what exactly does this mean for Maharashtra specifically, because the Nabam Rebia matter has gone to a larger bench, but the court is making certain observations with regard to democratic processes, accountability and democratic values, the powers of the incumbent government of Maharashtra. What the court has said is that not all procedural infringements are outside of judicial review, which basically means that the court is saying that they can in fact look into what has happened actually when it comes to the situation on the ground. Not all proceedings are outside the purview of judicial review, and that is a big point that is being made by the court about what has happened there. He's also talking about now, even as we speak, Polemy, the Chief Justice is still reading out his verdict. He's now going into what is the value of the whip, what is the power of the whip, and he's saying it is that you to say that only the legislative party appoints the whip will be too severe. The umbilical cord that connects the legislative party to the political party itself also has to be considered. This could very well be an important point being made in favor that the Uddhav Thackeray faction can take advantage of. Polemy, this is a very, very important point coming up, where the court is pointing out that legislators get their votes on appeal as members of a political party, and if they can later say that they are a legislative party separate from the political party that does not owe its allegiance to the main political party, will go against the principles of governance. This is a big point being made by the Chief Justice right now. Even as we speak, Polemy, the Chief Justice is
Anisha, catch a breath. I'm going to come right back to you. I want to cut across. Anisha, stay with me. The verdict still being read out where the Chief Justice of India is concerned on the issue of Maharashtra. On the other hand, it's been a big win for Arvind Kejriwal. But let's get you the latest with what is coming in. I want to quickly pull in Nalini as well. Nalini, the Chief Justice of India, still reading out the verdict. Break it down, at least for what we are getting to understand till now. It seems to be advantage Uddhav faction.
Well, Preeti, let's remember the 2016 judgment that is being spoken about, the Nabam Rebia judgment, had essentially said that during the time when the notice for the removal of a speaker is pending, at that time the speaker cannot decide on the disqualification of any of the MLAs. Now, considering the fact that Eknath Shinde and his MLAs had approached the Supreme Court saying that we've already put in a notice for disqualification of the speaker and therefore he cannot decide on our disqualification, considering the fact that the Nabam Rebia judgment has now been referred to a larger 7-judge bench, it will be advantage Eknath Shinde as well as all of his MLAs, because that means that they will continue to be in power in Maharashtra. There will be no stepping down either for the Eknath Shinde himself as the Chief Minister or his MLAs who've taken oath in the government. At the same time, the Supreme Court, the matter continues to remain pending in the Supreme Court, because now a 7-judge bench will look into the aspect as to whether or not a speaker can even decide on disqualification proceedings at a time when his removal or notice for his removal itself is pending. Essentially, what the Supreme Court has done, because this was one of the first requests that were made before the Supreme Court in this matter, that this 2016 judgment directly impacts this case, and that's why a bench of the same strength as was there in the Nabam Rebia judgment cannot hear this case. It should go to a larger bench. But at that time, the Supreme Court has said that we are not going to decide on as to whether or not a larger bench should hear this without hearing the merits of the case itself. So now that the merits of the case have been made clear before the Supreme Court has decided that Nabam Rebia, that says that powers of a speaker, there is no power of the speaker to decide on disqualification if a notice for his removal is pending. That will now be considered by a 7-judge bench of the Supreme Court, and only the outcome of that is likely to impact as to whether or not there will be any change in the government in Maharashtra. For now, there is absolutely no change that has been ordered by
for now. Nalini, stay with me. Coming right back to you. I want to cut across back to Anisha. She's got more coming in on what is transpiring in terms of the Chief Justice of India still reading out the judgment. Over to you, Anisha.
Paulami, this seems to be advantage Uddhav faction right now in the Supreme Court as the Chief Justice is continuing to read out his verdict. He has said that the Speaker at the time when he called Mr. Shinde's, when he appointed the whip recommended by the Shinde faction, was aware of the fact that there was a split within the party and that the Speaker must only recognize whip appointed by the political party. It is a big verdict coming in from the Supreme Court. This is going to be and as we speak, Paulami, the verdict is currently going on. He is also now looking into the powers of the EC. At this moment, the question now before the court is also whether the Election Commission could have taken the kind of steps that it did, and the time that it would take for the power of the Speaker to attain finality is uncertain. The Election Commission of India is a constitutional institution entrusted with the function of the maintenance and control of the electoral procedure. Election Commission cannot be prevented from performing its constitutional duty for an indefinite period of time. But the court is still, as I say, it is still going on. They are saying that work of one constitutional authority cannot be halted due to something happening before another constitutional authority. It seems to be that the court is trying to draw a very, very delicate balance between what happened in Maharashtra and what happened within the Shiv Sena, where on one hand the court has said that the Speaker could not have appointed a whip without referring to the political party in question. He has also now saying that the Election Commission does have the power to decide on who actually has control of the political party on the basis of the party constitution and other factors. And as I say, Paulami, the court is trying to create a very, very delicate balance here. They are saying the court is now looking into the question of disqualification proceedings and whether the court whether the court can go into this matter at all. He is saying that the decision of the ECI cannot be relied on by the Speaker for adjudicating disqualification petitions if those petitions are already pending, because the decision of the ECI would then have a retrospective effect. So clearly, Paulami, this is going to be a very, very complicated verdict, because on one hand, the court is saying that the Speaker could have taken a decision as far as the disqualification petitions are concerned, that the Speaker should have gone into an independent inquiry of who exactly is appointing the chief, the whip of the party in the assembly. But at the same time, it is also saying that the Election Commission could have done what it did. No faction or group can argue that they have a defense against disqualification on grounds of defection. It is a very, very important, very, very crucial point being made by the court that what is exactly the anti-defection process, what happens when there is a disqualification process. These are extremely technical points being read out by the court, and we are here trying to interpret what the court is really saying here, because this is not something that will only have an impact on the Maharashtra politics. This is something that is going to have a huge impact on the politics of the country in general. And the Chief Justice, of course, is, as we speak, still reading out his verdict. He is going into the question of what happens when there are two whips appointed by two separate factions of the party. The Speaker has to decide on which of the two whips represents the political party on basis of an independent adjudication. That is something that the court has just said, and we are still listening to the court, that we are answering this question with regard to the whip. We have answered this question on the whip. Only the whip appointed by the political party can be recognized, because the Election Commission proceedings on the recognition of the party would be a retrospective exercise. The Speaker should have gone into the consideration at that point.
What went down, catch a breath, Anisha, catch a breath. Coming right back to you, the Chief Justice of India still reading out the verdict. Trust us to get you one up on all developments. What happened in Maharashtra, viewers, was unprecedented. In terms of the judgment we are getting to hear, highly complicated, but you're in the best channel for you to break it down for you. And that's what we are doing. I want to quickly pull in Nalini. Nalini, complicated, yes. Interimly, it does seem advantage Eknath Shinde camp because status quo remains. Having said that, it is also a blow to Eknath Shinde. So it's a delicate balance there, because when you read into the Supreme Court stating Maharashtra Assembly Speaker could not have recognized Eknath Shinde camp MLA as whip of Shiv Sena. So there's a lot of contours to this judgment being read out. Can you break it down for the layman of what we have heard till now?
Well, Preeti, first thing we need to understand is that there are a lot of finer constitutional aspects that the Supreme Court is ruling on, including what the powers of the Speaker are, what the powers of the Governor are, in fact, even what the powers of the Election Commission and the Supreme Court are of judicial review when it comes to matters like this, where there is a split between the political party. Now, keeping that in mind, there are certain aspects that are bound to go in favor of Aditya Thackeray, and there are certain aspects that are bound to go in favor of Eknath Shinde. It depends how the pieces fall into place. At the same time, what the Supreme Court has said is that the appointment of the whip of the Eknath Shinde camp by the Maharashtra Assembly Speaker could not have been done, because only the whip appointed by the political party should be recognized. But at the same time, the Supreme Court is also speaking extensively about the powers of the Election Commission. Now, remember, the Election Commission had recognized the Eknath Shinde camp as the real Shiv Sena. But what the Supreme Court is saying right now is that it was not necessary for the Election Commission to rely on tests regarding legislature alone. The Election Commission must look into other tests also while it's deciding as to whether or not a symbol should be granted to a political party. What the Supreme Court is also saying is that the disqualification proceedings before the Speaker cannot be stayed in anticipation of proceedings before the ECI, which means that the ECI proceedings regarding any split between a political party should have no impact on the proceedings that are ongoing before a house on aspects of things like disqualification or even removal of a speaker for that matter. What the Supreme Court also said is that if disqualification proceedings are decided based on the ECI decision, then it is bound to have a retrospective effect and it will be contrary to law. Keeping in mind that they are both independent constitutional bodies, the decision of one should not impact the decision of the other. Especially the decision of the Election Commission should not have an impact on the proceedings before the floor of the House. The third question that the Supreme Court has considered is as to whether or not both the factions can actually even claim to be the real Shiv Sena in this case. And what the Supreme Court said in regard to that is that no faction or a group can argue that they constitute the original party and that this is a defense for disqualification.
You know, what's also interesting, and I'll bring in Anisha as well, but what's also interesting on the role of the governor, Mr. Koshari, the Supreme Court has said government had no objective material before him to believe that the incumbent government was not capable of running the government. Anisha. All right, we're going to cut across to Anisha and just about...
Yes, Preeti, now we are hearing we are keeping a constant eye. We are keeping a constant eye on what is happening in the court. I'm listening to the court as we speak. The court has very clearly said that a floor test cannot be used as a medium to resolve intra-party disputes. The governor must be cognizant of the constitutional norms. He should have taken into account what is happening. He cannot exercise a power that is not conferred upon him by the Constitution. The Constitution and the laws does not provide a mechanism by which a governor can look into disputes between the members of a political party. The governor was not empowered to enter the political arena. This is a big breaking news that I'm bringing to you. The court is reading out its order. The governor cannot act on an inference that he has drawn that a section of the Shiv Sena wishes to withdraw support from the government in the floor of the House. A floor test when it comes to the issue could not have been ordered by the governor. That is what the court seems to be saying at this moment, Preeti. What is the big takeaway from this section that is currently being read out by the court is that there is a presumption question of legitimacy once there is an elected government, that the MLAs had not specifically said that they are withdrawing their support from the Mahavikas Aghadi government. Nothing in the communication sent to the governor by the Eknath Shinde faction has at any point said that they intend to withdraw their support from the elected chief minister of the state. Very clearly, this seems to be advantage Uddhav right now.
There are so many points there, Anisha. Catch your breath, go through what the court is saying, coming right back with you. Let's break it down. Nalini, pulling you in as well. The contours of this judgment as complicated as what went down, which was unprecedented in Maharashtra. But interesting, when it comes down to the role of the speaker, when it has come down to the role of the governor, it seems to be advantage Aditya Thackeray, the latest, also coming in, which the Supreme Court says, Nalini, no attempt by opposition party to issue no confidence motion against incumbent government. These MLAs were only a faction at most, indicated dissatisfaction.
Yes, Preeti, like I told you, there are going to be certain aspects that are going to be in favor of both sides, considering what a complex issue this is. But I believe what the Supreme Court has said is that the governor had no objective material before him to believe that the incumbent government, which was the Uddhav Thackeray government at that time, was not capable of running the government, and therefore to ask him to face the floor test possibly was not done in the right manner. What the Supreme Court also said is that there was no attempt by the opposition party to issue a no confidence motion against the incumbent government, so the governor was not in a position to go ahead and ask for a floor test to happen. The Supreme Court's also gone ahead and said that once a government is democratically elected, there is always a presumption of legitimacy, which means that the democratically elected government should be allowed to function unless and until there is an objective material to show that they are not able to function legislatively. So keeping that in mind, the Supreme Court said
there's more coming in, Nalini. On the role of the governor, there's more coming in. Anisha, I'm going to cut across to you. I'm sorry I cut you short, Nalini, but important updates coming in from the court, Anisha, where the Supreme Court has said constitution authority derives power from constitution. Governor cannot exercise power not available under the constitution.
Well, Preeti, as we've been discussing, it is a very complicated, very nuanced judgment that is coming on from the court. What the Chief Justice is saying, that the governor ought not to have relied on the letter sent by the Shinde faction on the 22nd of June. There was nothing in that letter to show that the Uddhav Thackeray had lost the confidence of the House. The governor could not have considered the security concerns raised by the MLAs who had sent in the letter that they are facing threat to life and their property and their families. That was not enough for the governor to take a decision. Importantly, and Preeti, this is something that the Chief Justice is just saying, Devendra Fadnavis and the other MLAs could have moved a no confidence motion themselves, that they must, for the governor to take a decision unilaterally was incorrect. The governor did not have any objective material before him to indicate that the Uddhav government had lost the confidence of the House and that he should be calling a floor test, that the discretion of the governor was not in accordance with the law. A big point being made by the Supreme Court here. And now, of course, as we speak, Preeti, the Chief Justice is still reading out his verdict.
Hear it out, Anisha, coming right back to you. Hear it in, encapsulate your points. Like I said, it's a complicated judgment, but it was a complicated case on what went down in Maharashtra. Unprecedented, never had happened in Indian political history. Nalini, I'm going to bring you in because at least, with what we are hearing in from the Chief Justice of India right now, he's practically taken apart the role of Mr. Koshyari, the governor at that point of time.
Yes, Preeti, and this was one of the arguments that was made by the Uddhav Thackeray faction while the arguments were going on before the Supreme Court. They had questioned the order that was issued by the governor. They had specifically criticized his role in this entire crisis that had accrued in Maharashtra, and they had said that he was not entitled to make these political decisions in the first place. And that's precisely why even the Supreme Court, regarding the role of the governor, has gone ahead and said that the governor is not entitled to enter the political arena and play a role in an intra-party to inter-party dispute. He cannot act on the basis is that some members want to leave the Shiv Sena and the governor cannot...
More so coming in, very interesting. I'm sorry I'm coming in, but more so coming in, and it's very, very interesting because the latest is that the court says had Uddhav Thackeray not resigned, the court could have given relief. Trust vote was not held.
Yeah. Yes, Preeti, that's the latest coming in from the Supreme Court. Where the Supreme Court said, and it's CJ Chandrachud who's reading out the verdict, he said that had Uddhav Thackeray not resigned, this court could have given relief. Remember, instead of facing the floor test, Uddhav Thackeray had put in his resignation after the order from the governor had come in this aspect, and that was the time when the matter was still going on before the Supreme Court. The Uddhav Thackeray faction had approached the Supreme Court trying to get a stay on the floor test, but at that time no stay was granted. But one thing that the Supreme Court had said is that anything that happens in Maharashtra will be subject to the final outcome of the Supreme Court, which is what is being pronounced today. So whatever is decided today by the top court is what is going to determine the future of the government in Maharashtra. And what the Supreme Court has said is that there was a possibility of Uddhav Thackeray getting relief if he had not resigned as the Chief Minister and had gone ahead and conducted the trust vote first. At the same time, they're also saying that the governor in this entire aspect should not have entered the political arena, and without any objective material before the governor, they should have not asked Uddhav Thackeray to face the floor test because there was no reason provided as to why the government could not...
I want to ask you, Nalini, I want to ask you from a layman term. The Supreme Court saying Devendra Fadnavis, independent MLAs, didn't move a no-confidence motion. Governor exercise of discretion was not in accordance with the law. The role of the Speaker. Is the Supreme Court indicating that the Maharashtra's current government is illegal?
Preeti, we will not go so far as to speculate that, but let me tell you what the Supreme Court is saying. The Supreme Court is saying that this is an intra-party dispute. There were some MLAs within the Shiv Sena that were not happy, that wanted to break away from the party, and there was a rift between different factions of the same party. But at the same time, this was not enough for the governor to go ahead and call the government's functioning as not a possibility. There was no objective material before him to go ahead and say that the government is not going to be able to function properly and force Uddhav Thackeray at that point to face the floor test. So that is essentially what the Supreme Court
it's very interesting. Nalini, it's very interesting because the latest that's also coming in, and Anisha, I'll bring you in. Because the court has said, had Uddhav Thackeray refrained from resigning, this court could have reinstated him. But the court cannot quash a resignation. This is huge. Anisha, can you hear me?
Yes, Preeti, this is a very, very delicate balance that the court has made. If you can hear me.
Yes, go ahead.
Preeti, can you hear me? Hello? Yes, if you can hear me, Preeti, this is a big moral victory right now for Uddhav Thackeray, but since he had resigned, the court has very clearly said, we cannot restore you to the government because you chose to resign. However, politically and legally, the court has given a huge amount of ammunition to the Thackeray faction right now by saying that the governor as well as the speaker acted outside of their purview. They could not, the speaker could not have recognized a whip which was not from the political party, but the status quo ante cannot be restored because the governor called the leader of the largest party in the house, and Eknath Shinde had been recognized at that time by the trust vote as the leader of the house. So after a huge moral victory for the Uddhav faction, legally and politically, Eknath Shinde government will continue in Maharashtra, because even as the court has said that the governor and the speaker as well as Devendra Fadnavis and his supporters acted outside of their purview, but with Uddhav Thackeray's resignation, Eknath Shinde was recognized by the house as the leader of the house, and that is why the governor was justified in inviting him to form the government. A big moral victory right there for Uddhav Thackeray, that what happened was not correct, but at the same time, because he himself resigned, he does not get a win, he does not get back the government of Maharashtra. Very clearly, Preeti, this verdict is going to be something that will set out the future of politics in the country. It will set out how a split in the party is considered going forward. But for today, for Maharashtra, this is something that Uddhav Thackeray has lost out on. Back to you.
Well, interesting. We are breaking it down, viewers. So, what it seems to suggest with all the points that are coming in from the Supreme Court as of now, seems to suggest that it's a big moral victory, which Anisha said, when it comes down to the Uddhav Thackeray faction. But that's what it is, because the incumbent government stays primarily. Nalini, I'm going to pull you in on this, stating that had Uddhav Thackeray, and that's the key, had Uddhav Thackeray not resigned, the court would have reinstated him. However, he did not take a floor test. The governor was correct then, calling upon the Eknath faction to form government. Interesting what's going down. One can understand that the Uddhav Thackeray faction will make a political meal of it when it comes down to, the moral victory angle. But on the other hand, the incumbent government stays.
Well, yes, Preeti, and I believe what the Supreme Court is saying at this point is that the governor had only simply relied on a letter that was given by Devendra Fadnavis along with several MLAs. And what these MLAs could have done instead of going to the governor was actually move a motion of no confidence before the assembly itself. Nothing stopped them from doing that, but they did not do that. They went to the governor. So the Supreme Court has actually criticized the actions of the governor, saying that there was no objective material before the governor to call for a floor test, and his decision for calling for a floor test was actually not in terms of law. That is what the Supreme Court said, criticizing the decision of the governor. But in the same breath, they have gone on to say that had Uddhav Thackeray not resigned, this court could have given him relief. The trust vote was not held. Both the Speaker and the Election Commission are well empowered to concurrently adjudicate on this aspect. But the governor at the same time was not justified in calling Uddhav Thackeray to prove the majority before the House. So there is a problem on both sides, where on one side, the order of the governor calling for the floor test should not have been passed because there was no objective material, and the MLA should have moved before the assembly with a no confidence motion instead of going to the governor instead. But on the other side, Uddhav Thackeray should have faced the trust vote, is what the Supreme Court is saying. Uddhav Thackeray today would have been in a far better position. He could have hoped for some relief from the Supreme Court in case he had faced the trust vote, which he did not do, and instead he went on and resigned as the Chief Minister of Maharashtra. Which means that the Supreme Court is saying that the governor was not justified in calling Thackeray to prove the majority, and that the status quo cannot be restored right now as Thackeray did not take the floor test. So that's a big setback coming in for Uddhav Thackeray, where the Supreme Court has not only ruled against him and his faction, but they've also pinned the blame on him for making sure that there is no relief coming in from the top court, because he did not face the floor test in the very first place. And in case he had done that instead of resigning, the Supreme Court could have tried to offer him some relief in these final constitutional aspects. The governor was not justified in calling for a floor test, but because of the fact that
Nalini, stay with me. Would you just stay with me? Let's just break it down. I want to quickly cut across. Priyanka Chaturvedi is joining us on the phone line from UBT, the Uddhav faction. Priyanka Chaturvedi, you can go back home with a moral victory, but the sheer fact of what you wanted relief, that hasn't come. And the blame is on you. You should not have quit. If you faced the floor test, possibly it would have been different today.
No, I am really sorry. You've misunderstood the judgment. If he has called the disqualification, the appointment of the whip as an illegal act, the governor's act of calling for a floor test, which is unconstitutional, illegal, going beyond his authority. It's not just a moral victory. It's a victory of India's constitution. Now, it is now in the domain of the Speaker of the House to ensure that those whose disqualification we seek is heard by him, by the Chief Whip appointed by us, which is Sunil Prabhu. And I do not think that the decision on this particular instance of not ensuring the status quo ante was something that we were really fighting for. What we were fighting for was the illegality of everything the governor was doing, illegality of the decision of conducting a floor test, illegality of these MLAs appointing a Chief Whip and Leader of the House. And that has been upheld by the Supreme Court.
But Priyanka Chaturvedi, the fact is, yes, that has been upheld by the Supreme Court in terms of, what the Supreme Court has said on the role of the governor practically taking him apart, the role of the Speaker. But in the end of the day, what is it that you had hoped to achieve from the top court of the country? Because the current incumbent government stays, Ms. Chaturvedi. And the blame is on you.
current
If you had
incumbent
faced the floor test, it would have been a different outcome possibly.
No, even if the entire consequences of conducting a flow test, the immoral way the flow test was conducted by appointment of an illegal whip, that in itself shows that they have lost the moral authority to govern. Now, it is for the people of the state to understand, and that is exactly what the Chief Justice has said, that these are people appointed under the party symbols. And in fact, he has also told the Election Commission the decision that they have taken cannot be only on the basis of the legislative strength of those who have defected. So those are huge judgments coming in our favor, which will go in a long way to ensure that this kind of bending of constitutional authority and bypassing the 10th schedule, bypassing the anti-defection law, cannot function in India's democracy.
Ms. Chaturvedi,
I look at it as a huge
okay, all right. You look at it as a win, but I'm just going to cut across to Sanjay Raut from your own party speaking right now. Listen in.
सुप्रीम कोर्ट का अगर आप निर्णय देखें तो हम खुश हैं कि देश में लोकतंत्र और न्याय व्यवस्था आज भी जिंदा है। संविधान मरा नहीं है या कोई संविधान की हत्या नहीं कर सकता। सत्ता आती है, सत्ता चली जाती है। सबसे पहले जो सुप्रीम कोर्ट ने कहा है कि जो शिंदे गुट का व्हीप है वही गैरकानूनी इलीगल है, उसका मतलब है वो लोगों ने जो व्हीप बजाया था वो गैरकानूनी है, और हमारा जो व्हीप था उसने जो आदेश दिया है वो कानूनी है। वो उस व्हीप के मुताबिक तो सब लोग अभी डिस्क्वालीफाई हो जाएंगे। विधानसभा अध्यक्ष को अधिकार है, ठीक है, लेकिन लीगल व्हीप कौन है? प्रभु है। ये सर्वोच्च न्यायालय ने कहा है, तो क्या विधानसभा के अध्यक्ष गैर कानूनी काम करेंगे? क्या संविधान की हत्या करेंगे? नहीं, पण एखादी मुदत त्यांना बरोबर आहे। लवकरात सर्वोच्च न्यायालयाच्या सगळ्या घडामोडींवर लक्ष आहे आणि विधानसभेचे अध्यक्ष या डॉक्टर आंबेडकरांच्या महाराष्ट्रामध्ये संविधानाची हत्या करू शकत नाही। नैतिकतेच्या मुद्द्यावर ताबडतोब मुख्यमंत्र्यांनी आणि त्यांच्या सरकारने राजीनामा द्यायला पाहिजे। उगा टाळ्या वाजवत बसू नये। राज्यपालांची प्रत्येक भूमिका बेकायदेशीर आहे।
सर, आपने जो पॉइंट रखा है वो शिंदे सरकार आता तरी कायम असल्याचं दिसतं।
अरे सोडा, कायम बेम कसलं आहे? गेलं ते सरकार।
राव सर, आपने जो पॉइंट रखा है उद्धव ठाकरे अगर रिजाइन नहीं देते तो
ये बात सही है। कानूनन मुद्दा है कि उसका ही मतलब है अभी की सरकार गैर कानूनी है। अगर सुप्रीम कोर्ट ये कहते हैं कि अगर उद्धव जी ने नैतिकता के आधार पर रिजाइन किया है, इस्तीफा नहीं देते, तो आज हम उस स्थिति में होते कि उद्धव ठाकरे जी को मुख्यमंत्री के तौर पर फिर एक बार स्थापित करते। उसका मतलब है जिस तरह से सरकार नई सरकार बनाई ये पूरी तरह से गैर कानूनी है और संविधान के खिलाफ बनी है। दूसरी बात सर्वोच्च न्यायालय ने जो कहा है कि शिवसेना किसी गुट की नहीं हो सकती, ओरिजिनल पार्टी है, उनके पास रहेगी। मैं मानता हूं, मैं सर्वोच्च न्यायालय का आभारी हूं।
All right, Sanjay Raut there saying that this government is illegal. But what is really interesting, viewers, and I want to bring in our two crack legal reporters on this, because what the Supreme Court has done today is, if you look at the contours of this judgment, very interesting, because what the Chief Justice of India read out practically stated that everything leading up to the instatement of Eknath Shinde as the Chief Minister was illegal, but the government stays. Let's listen in to all the reactions that are coming in.
The court has clarified that had Mr. Thackeray would not have resigned, then in that scenario, a status quo ante would have been granted. But now since he had resigned himself, therefore court can't do anything.
So the court also basically stated if Uddhav, after Uddhav resigned, then it was absolutely legal to call in for a floor test by the governor.
That I could not hear. Once the judgment is out, we'll clarify.
Just to clarify, what has the court said regarding the role of the governor?
It said that the governor should not have taken into account because there was no objective material on the record.
So effectively what the Shinde faction MLA said was not objective material to topple a government, but because the government resigned by itself, therefore they will not get any relief.
That's what I can understand. Once the judgment is out, we'll clarify.
With regards to the whip, the Supreme Court had certain observations.
So on the issue of whip, yes. On the issue of whip,
that was
I'll answer this question first. On the issue of whip, the court has said that the whip of the political party will be given primary consideration.
But at this point of time, then who will be the new whip? Will be the
There are also senior advocates and political leaders coming out now.
Abhikal.
Just speaking.
आप किसके तरफ से तय कर रहे हैं?
There are also senior advocates and political leaders coming out now.
All right, so once again, viewers, let me break it down for those who are joining us. Yes, it's a huge moral victory when it comes down to the Uddhav faction, but ultimately, what has transpired? No relief for the Uddhav faction. Eknath Shinde remains as the Chief Minister of Maharashtra. To break it down further, the Chief Justice of India, practically on the role of the governor, on the role of the speaker, on Mr. Devendra Fadnavis, on whatever his observations were leading up to the judgment, was very clear that, if you try and interpret it, everything leading up to the instatement of Mr. Eknath Shinde as Chief Minister seemed to suggest was illegal by what the top court said. But Eknath Shinde still remains as the Chief Minister because Mr. Uddhav Thackeray chose to resign and did not face a flaws test. The court said very clearly that had Mr. Thackeray not resigned, then he could have been reinstated by the top court, but now nothing can be done.
इलेक्शन कमिशन ने माननीय मुख्यमंत्री एकनाथ शिंदे साहेबांकडे दिलेले आहे, त्यामुळे तो पण मुद्दा आता क्लिअर झालेला आहे. त्यामुळे आता पॉलिटिकल पार्टी इलेक्शन कमिशनच्या जी प्रोसिजर आहे त्या संदर्भात पण माननीय न्यायालयाने टिप्पणी केलेली आहे, तर ती त्या संदर्भात नंतर क्लिअरिटी येईल. परंतु इलेक्शन कमिशनने आता माननीय मुख्यमंत्री एकनाथ शिंदे साहेबांकडे शिवसेनेची धुरा दिलेली आहे. त्यामुळे पॉलिटिकल पार्टीचे संपूर्ण अधिकार एकनाथ शिंदे साहेबांकडे आहे आणि त्यामुळे पॉलिटिकल पार्टीचा व्हीप हा ग्राह्य दिला जाईल.
निवडणूक आयोग घेऊ शकतो असं पण सांगितलं आहे की निर्णय त्याचा निवडणूक आयोग देऊ शकतो.
हा निवडणूक आयोग पूर्ण निर्णय देऊ शकतो. निवडणूक आयोगाने ऑलरेडी निर्णय दिलेला आहे. त्यामुळे निवडणूक आयोगाने जो निर्णय दिलेला आहे की पॉलिटिकल पार्टी एकनाथ शिंदे साहेबांकडे आहे, तर त्यामुळे हे तीन निर्णय अत्यंत महत्त्वाचे आहे की सरकार गोगावलेंची नियुक्ती बेकायदेशीर ठरली नाही, ती प्रोसिजरच्या संदर्भात त्यांनी उल्लेख केलेला आहे. पॉलिटिकल पार्टीने त्याचा नियुक्ती करायला पाहिजे आणि आता इलेक्शन कमिशनने पॉलिटिकल पार्टीचे अधिकार माननीय एकनाथ शिंदे साहेबांकडे दिल्या कारणामुळे पॉलिटिकल पार्टी आता एकनाथ शिंदे साहेबांच्या आणि एकनाथ शिंदे साहेबांनी नियुक्त केलेला व्हीप भरत शेठ गोगावले आहेत, त्यामुळे तो अधिकृत व्हीप आहे. याचा निर्णय आता स्पीकर घेतील, कारण पॉलिटिकल पार्टी
राज्यपालांनी जो निर्णय घेतला त्यावर परंतु जे
एक नाही बरोबर, राज्यपालांच्या भूमिकेच्या संदर्भात पण माननीय न्यायालयाने टिप्पणी केलेली आहे, परंतु माननीय न्यायालय या संदर्भात आपली भूमिका स्पष्ट केलेली आहे. परंतु आता क्लॅरिटी झालेली आहे, या सरकारला कुठला धोका नाही. अपात्रतेच्या संदर्भात पण निर्णय आता स्पीकर घेतील. आज बड़ी राहत है. माननीय सर्वोच्च न्यायालय ने जो निर्णय लिया है वो निर्णय का हम लोग स्वागत करते हैं. जो नाबाम रेबिया का रेफरेंस दिया था उसमें 179 और 180 में कुछ अमेंडमेंट करने की ज़रूरत है, तो वो लार्जर बेंच के पास उन्होंने रेफर किया, क्योंकि कॉन्स्टिट्यूशन में अगर चेंजेस करना है तो लार्जर बेंच के पास वो जाना चाहिए, ऐसा सुप्रीम कोर्ट ने कहा हुआ है. और जो अपात्र के गवर्नर के बारे में भी माननीय सर्वोच्च न्यायालय ने जो टिप्पणी की है उसके बारे में उनकी जो प्रोसीजर है प्रोसीजर फॉलो करने के बारे में. लेकिन अभी जो व्हीप अपॉइंट किया हुआ है वो पॉलिटिकल पार्टी व्हीप अपॉइंट कर सकती है और इलेक्शन कमीशन के निर्णय
comments made on election commission, but election commission already given its order on who the real Shiv Sena is. There have been comments made on the appointment
जो हमारे व्हीप है वो ऑफिशियली है, उसका निर्णय अभी स्पीकर लेंगे. माननीय न्यायालय ने ये भी कहा कि जो भी अपॉइंटमेंट है वो पॉलिटिकल पार्टी के थ्रू होनी चाहिए. तो अभी इलेक्शन कमीशन का जो डिसीजन है वो बहुत ही इंपॉर्टेंट है कि उन्होंने पॉलिटिकल पार्टी के पूरे राइट्स एकनाथ शिंदे साहब के पास देने की वजह से तो पॉलिटिकल पार्टी की जो अपॉइंटमेंट है वो सब ऑफिशियल है. अभी इसका निर्णय पूरा स्पीकर साहब लेंगे और विद इन उनको एक टाइम लिमिट दिया.
सरकार को बहुत बड़ा रिलीफ है,
बहुत बड़ा रिलीफ है, क्योंकि बहुत महाराष्ट्र के के जो पॉलिटिकल जो एटमॉस्फेयर था बहुत ही ख़राब था, जो अनस्टेबल था पूरा, और अभी एक स्टेबल गवर्नमेंट मिलेगी, स्टेबल एटमॉस्फेयर हो जाएगा और पॉलिटिकल सिचुएशन पूरी स्टेबल हो जाएगी। मैं माननीय न्यायालय का जो भी निर्णय है उसका स्वागत करता हूँ।
राहुल जी सवाल एक ये है कि कोर्ट ने ये भी कहा कि अगर उद्धव ठाकरे रिजाइन नहीं करते तो रीइंस्टेट करने की बात होती है, और जो अब शिंदे सरकार के लिए जो उनका रीइंस्टेटमेंट था, जो उनको सीएम बनाया गया, उसको कम्प्लीटली एक तरह से इलीगल कहा है। सरकार ने कहा है कि वो लीगल है, लेकिन ये कहा है कि अगर उद्धव ठाकरे रिजाइन नहीं करते तो रीइंस्टेट करने की बात होती।
त्या मुद्द्यांवरती बरीचशी क्लिअरिटी आज आलेली आहे। आज सुप्रीम कोर्टाने शिंदे सरकारला, राज्यपालांना ज्या पद्धतीने फटकारलंय ते एक एक मुद्दे मी आपल्याला सांगतो। हे पिटिशन परत अध्यक्षांकडे पाठवण्यात आलेलं आहे। हे पिटिशन डिसाईड करताना अध्यक्षांनी व्हीप कुठला असावा हे ठरवायचं आहे, आणि हे ठरवताना आज सुप्रीम कोर्टाने अतिशय स्पष्ट सांगितलेलं आहे की व्हीप हा पॉलिटिकल पार्टीने नेमलेलाच व्हीप असायला पाहिजे। त्यावेळेचा जो व्हीप होता हे सुनील प्रभू होते, त्यामुळे सुनील प्रभूंनी दिलेले आदेश हेच ह्या पिटिशन मध्ये अंतिम ठरणार आहेत, हे आज अतिशय स्पष्ट झालंय। तिसरी गोष्ट, राज्यपालांनी जे अधिवेशनाच्या संदर्भात फ्लोर टेस्टचे जे आदेश दिले होते, कारण सबळ पुराव्याच्या अभावी, सबळ डॉक्युमेंटच्या अभावी अशा प्रकारे राज्यपालांना फ्लोर टेस्ट बोलवता येत नाही। केवळ काही आमदारांनी पत्र दिलं म्हणून फ्लोर टेस्ट बोलवता येत नाही।
Governor shouldn't have called for a floor test just on the basis of some letters from some MLAs.
याची पडताळणी करून फ्लोर टेस्ट असेल किंवा अधिवेशन बोलवण्याचं काम केलं पाहिजे। मला वाटतं भारताच्या इतिहासामध्ये राज्यपालांना अशा पद्धतीने पहिल्यांदाच फटकारलं गेलं आहे।
For the first time in Maharashtra's history has a governor been in fact reprimanded in such a manner.
नवम्र केस आहे, ही 7 बेंचच्या समोर गेलेली आहे, त्यामुळे अध्यक्षांचे अधिकार हा एक वेगळा विषय झाला। पण जरी आताच्या अध्यक्षांच्या समोर जाईल त्याच्यामध्ये सुनील प्रभू हेच व्हीप असतील आणि सुनील प्रभूने दिलेले आदेश हेच मान्य करावे लागतील। त्यामुळे ही क्लिअर कट अधी गोष्ट स्पष्ट झालेली आहे की सुनील प्रभूंचे आदेश ज्यांनी मानले नाहीत ते डिस्क्वालिफिकेशनला पात्रता ठरतात।
It's become clear that whoever did not listen to Sunil Prabhu, they are in fact
जे 3
to face disqualification.
आहे त्याच्या बाबतीत देखील सुप्रीम कोर्टाने सांगितलेलं आहे की मर्जरचा जो पर्याय आहे हाच फायनल आहे। त्याच्या बाबतीमध्ये देखील राज्यपालांनी योग्य तो सभा अध्यक्षांनी योग्य तो निर्णय घ्यावा। त्यामुळे
Supreme Court has also said that merger is the only alternative.
हे अतिशय स्पष्ट झालं आहे की हे 16 आमदार डिस्क्वालिफिकेशन पासून वाचू शकत नाही।
It's become clear that these 16 MLAs can't escape disqualification.
29 आमदारांचं पिटिशन आमचं जे अध्यक्षांकडे पेंडिंग आहे ते देखील रिझनेबल टाइम मध्ये घेतलं पाहिजे।
A decision has to be taken on our petition which is before the governor.
आम्ही ताबडतोब सुप्रीम कोर्टात येऊ, पण आजच्या निर्णयाचा फटका हा शिंदे सरकारला बसलेला आहे आणि त्यामुळे
has been a scathing slap on the Shinde Sarkar's face.
असेल तर शिंदे सरकारने ताबडतोब राजीनामा दिला पाहिजे।
Shinde government should step down immediately.
रिझनेबल टाइम हा एका केसमध्ये मणिपूरच्या ठरलेला आहे, 3 महिन्याचा रिझनेबल टाइम आहे। परंतु सुप्रीम कोर्टाच्या आदेशाची प्रत मिळताच आम्ही अध्यक्षांकडे अप्रोच होऊ। त्याचं कारण असं आहे की तो फुलपेज ह्याच्यामध्ये आदेश दिला होता, आम्ही 10 ते 15 दिवसातच हे पिटिशन ऐकून घ्यावं, कारण ह्याच्यामध्ये व्हीप अतिशय स्पष्ट झालेला आहे की व्हीप सुनील प्रभूच असणार आहे।
It's become clear that the whip will be Sunil Prabhu.
मध्ये व्हायोलेशन झालंय हे ऑलरेडी रेकॉर्डवरती आलेलं आहे।
Now there has been a violation and that's on record.
याच्यामध्ये पुरावे तपासायची गरज नाही, कारण सगळ्यांनी हात वर करून त्यांच्या व्हीपचं व्हायोलेशन केलेलं आहे, तोंडी व्हायोलेशन केलेलं आहे।
Everyone who in fact raised their hands during the floor test have violated the whip.
मध्ये जास्त वेळ लागणार नाही, कारण सगळे पुरावे विधानसभेच्या रेकॉर्डवरती आहेत, फक्त तपासायचे आहेत आणि याच्या बाबतीतला निर्णय द्यायचा आहे. त्याच्यामुळे ही काही मोठं सायन्स रॉकेट सायन्स नाहीये. म्हणून 10 ते 15 दिवसामध्ये हे सरकार जाईल असा आमचा अंदाज आहे.
10 to 15 days this government will go.
राहुल शेवाळे काय म्हणतात याला मी जास्त महत्व देत नाही.
I don't give much importance to what Rahul Shewale says.
म्हणतात मी याला जास्त महत्व देतो. आज सुप्रीम कोर्टच्या जजेसने जे सांगितलेलं आहे तेच मी आपल्या समोर सांगतोय.
I give more importance to what the Supreme Court says. I'm saying to you what the Supreme Court has said.
राहुल शेवाळे काय म्हणतात याला मी फार महत्व देत नाही. माझं म्हणणं असे सुप्रीम कोर्टाने आज काय म्हटलंय हे जास्त महत्वाचं आहे. त्याच्यामुळे त्यांना दिलासा आहे फक्त 15 दिवसाचा.
They might have got some relief, but it is only going to last 15 days.
नक्कीच आम्ही असं नाहीये. उद्धव ठाकरेंनी राजीनामा, त्यांनी एकच मुद्दा सांगितला, उद्धव ठाकरेंनी राजीनामा दिल्यामुळे आम्ही स्टेटस को देऊ शकत नाही. म्हणजे याचा अर्थ तुम्ही नीट समजून घ्या की याचा अर्थ त्यांची ऍक्टिव्हिटी इलिगल झालेली आहे हे जवळपास कोर्टाने मान्य केलंय.
The court has admitted that their activity was illegal when they say that because Uddhav Thackeray resigned, we couldn't give any relief, but they've admitted to the illegality of what happened beforehand.
की हे ऍक्टिव्हिटी इलिगल झालेली आहे. आम्ही आता जजमेंटची कॉपी हातात आल्यावरती ती घेऊन अध्यक्षांच्या समोर जाऊ.
We'll go to our party president with the judgment order copy.
याच्यामध्ये वेळ काढण्यासारखी परिस्थिती नाही. सगळे पुरावे उपलब्ध आहेत.
We have all the evidences and proof.
रेकॉर्डवरती आहेत.
It's all on record.
तपासून निर्णय द्यायचा आहे आणि व्हीप एकदा फायनल झालेला आहे.
When the whip is final,
आहेत त्याच्यामुळे आता परत याची चौकशी करत बसण्याची किंवा याच्यावरती कुठलाही अजून डोकं लावून नवीन जजमेंट्स वाचायची गरज नाही.
There's no need to look at anything new.
लेकिन एक बात है कि यहाँ पे जो लोगों के मन की सरकार थी वो सरकार सुप्रीम कोर्ट ने उसको यहाँ पे बचाया है. निश्चित तौर पर विकास के लिए ये सरकार का यहाँ पे रहना बहुत जरूरी था. मैं ये सुप्रीम कोर्ट के निर्णय का स्वागत करता हूँ.
लेकिन जो उद्धव ठाकरे गुट है वो तो सीधा हमला कर रहा है कपिल साहब. उनका ये सीधा आरोप है कि स्पीकर ने गलत फैसला लिया, भरत गोगावले को व्हिप अपॉइंट करके, राज्यपाल ने गलत फैसला लिया. तो फिर नैतिकता पर आप लोग कहां टिकते हैं?
ये तो सुप्रीम कोर्ट ने जो दिया है आज, इसका मैंने वही कहा कि अभी इसके ऊपर जो विधानसभा का अध्यक्ष जो है वही निर्णय जो सुप्रीम कोर्ट का आया है इसका स्टडी करके वही कुछ बता सकेंगे. उसके निर्णय के ऊपर मैं कुछ टिप्पणी करूं तो मैं तो उसके लिए सक्षम नहीं हूं. और राज्यपाल के निर्णय के ऊपर भी मैं क्या टिप्पणी कर सकता हूं?
नहीं, लेकिन जो शिवसेना के जो उद्धव गुट कह रहा है उस पर तो टिप्पणी कर सकते हैं ना. वो कह रहे हैं कि आप लोग का मॉरल स्टैंडिंग हिल गया. जी बोले कपिल साहब.
पहले दिन से कह रहे थे कि ये सरकार असंवैधानिक है. वो तो सुप्रीम कोर्ट ने उनकी बात खारिज कर दी. उसके ऊपर वो कुछ टिप्पणी नहीं करेंगे. वो तो अपना ही चलाएंगे. अभी वो अपोजिशन में चले गए हैं तो वो तो अपनी बात ही कहेंगे.
तो आप लोग जश्न मनाएंगे कि अब तो आप लोगों की सरकार बरकरार रहेगी, लेकिन वो लोग हमला तो और तेज करेंगे ना. अब 24 तक, 24 में से हथियार के तौर पर इस्तेमाल किया जाएगा ना.
देखो ऐसा है अभी 2024 का चुनाव है. 1 साल उसको इंतजार करना पड़ेगा. उस वक्त कोई कौन सा हथियार यूज करता है, उसके बाद और कोई हथियार यूटी के पास भी आ जाएगा. ऐसा उस वक्त किसने देखा है 2024 का. भी हमारा मुद्दा तो हम तो चुनाव में विकास के मुद्दे पे जाने वाले हैं.
Let's cut across to Mr. Girish Mahajan. He's Minister of Medical Education, Maharashtra, from the BJP. Mr. Mahajan, appreciate you joining me. You know, sir, today you can say that yes, the Supreme Court ultimately has reinstated or had shown faith that the continuance of the Eknath Shinde government. But the moral victory today clearly goes to Uddhav Thackeray, where the Supreme Court elucidated very clearly, sir, that what can be interpreted, that everything that went into instatement of Eknath Shinde as the Chief Minister was illegal.
हेलो, आज एक बहुत महत्वपूर्ण निर्णय माननीय सर्वोच्च न्यायालय ने दिया है जिसका इंतजार पूरे देश को था, महाराष्ट्र को ही नहीं. और एक अच्छा निर्णय. मुझे ऐसा लगता है कि डेमोक्रेसी में हम लोग कहते हैं कि जिसके पास मेजॉरिटी है तो वही सही होता है. तो आज देखो, उद्धव जी को छोड़कर जब 55 में से 41 एमएलए जब निकल जाते हैं तो उनके पास 14 एमएलए बचे हुए थे। बिल्कुल सीधी बात है, क्योंकि उनके हाथ से पूरी पार्टी निकल गई थी, उनका वहाँ कुछ बचा भी नहीं था और उसके बाद तो उन्होंने रिजाइन भी कर दिया था। अब रिजाइन देने के बाद में वो कहेंगे कि भाई हमारी सरकार हम ही लीगल है, तो मुझे लगता है ये बहुत गलत बात थी।
पर गिरीश महाजन जी, नैतिकता पे आपकी ये बात कहाँ बैठती है? अगर आप देखें जो भी सुप्रीम कोर्ट ने कहा है, चलिए उन्होंने ये तो माना है कि एकनाथ शिंदे की जो सरकार है वही अभी रहेगी, पर महाजन जी उन्होंने साफ ये भी बोला है कि जो भी हुआ ये सरकार बनाने में आप उसको इंटरप्रेट कर सकते हैं कि सब इलीगल है। और उन्होंने ये भी कहा है कि अगर एक उद्धव ठाकरे जी रेजिग्नेशन ना देते तो फिर कोर्ट उनको रीइंस्टेट कर सकती थी।
हाँ, लेकिन उनको भी पता चल गया था कि हमारे साथ अभी लोग नहीं रहे। 11-12 एमएलए उनके साथ बचे थे, 40 लोग 41 विधायक जो थे उनको छोड़ चुके थे। उसके बाद में उन्हें भी था कि भाई अभी मैं क्या करूं, इतना इंसल्ट उनका होता था कि उनके साथ 10 लोग भी नहीं बचे हुए थे। उसके बावजूद क्या करते थे वो? और कोई नेता के खिलाफ कोई पार्टी
महाजन जी, बात कितने लोग बचे ये नहीं थे, बात बहुत सारे और आंकड़े इसमें आ रहे हैं। जो गवर्नर का रोल उस पे सवाल उठाए जा रहे हैं, स्पीकर का रोल उस पे सवाल उठाए जा रहे हैं, और साफ साफ ये भी कहा है कि जो ऑफिशियल व्हिप, लीगल व्हिप है, जो लीगल व्हिप है वो अभी सुनील प्रभु जी हैं जो ठाकरे फैक्शन के हैं।
नहीं, अभी तो लीगल, अभी उन्होंने बताया कि उस वक्त वही थे, अभी वही है, लेकिन अभी तो नेता गट के अभी शिंदे साहब है, अभी वो दूसरा व्हिप चुन सकते हैं, अभी दूसरा व्हिप मीटिंग लेकर वो भी चेंज कर सकते हैं या नया व्हिप दे सकते हैं। ये भी कोर्ट ने तो अभी साबित कर दिया कि इनकी सरकार है, अभी नेता ये है। तो मुझे ऐसे लगता है कुछ भी हुआ तो आज का निर्णय ये बहुत महत्वपूर्ण है। और उसके बाद इन्होंने अगर रिजाइन नहीं
All right, we seem to have lost Girish Mahajan midway. But you know what is interesting is that both factions here, be it the Shiv Sena, Uddhav Thackeray and the Eknath Shinde faction, will claim victory, will claim what has happened in court as their victory. The Shinde faction will say it's relief to their government, while the Thackeray faction will clearly say that the whip, Sunil Prabhu, is the recognized whip, while the Shinde faction appointed whip has been called as illegal. So both factions will come out claiming victory from what has happened in Supreme Court today, viewers. But it's very, very interesting because what really went down in Maharashtra was unprecedented. It's a complex judgment. Ultimately, it says that Eknath Shinde remains as Chief Minister of Maharashtra. His government stays. However, with whatever the observations were of this judgment, clearly seem to suggest that the process of it was illegal. More so that the official recognized whip is Mr. Sunil Prabhu of the Uddhav faction and not of the Bharat Gogavle of the Eknath Shinde faction. Listen in to all reactions coming in.
सर, आपकी सरकार से खतरा फिलहाल तौर पर लगता है कि हट गया है, आप संतुष्ट हैं जो फैसला आया है?
हम संतुष्ट है। हमारे सरकार को पहले भी खतरा नहीं था, आगे भी खतरा नहीं होगा, क्योंकि हमने जो भी प्रोसीजर किया है वो कॉन्स्टिट्यूशन को फॉलो करके किया है और माननीय सर्वोच्च न्यायालय ने वो एक्सेप्ट किया हुआ है। और जो भी माननीय सर्वोच्च न्यायालय का जो निर्णय है उसका हम स्वागत करते हैं।
आप स्वागत कर रहे हैं, लेकिन गवर्नर को लेकर काफी सवाल उठाए हैं, जिस तरीके से प्रोसीजरल फ्लॉज के बारे में उठाया गया है। आपको लगता है कि ये सब चीजें आपके फेवर में नहीं जाएंगी आगे चलकर?
नहीं, अब गवर्नर ने जो डिसीजन लिया तो गवर्नर का इंडिविजुअल डिसीजन है, वो कॉन्स्टिट्यूशन के हिसाब से किया है, प्रोसीजर फॉलो करके लिया है। और उस दिन उस वक्त जो एटमॉस्फेयर था, वो जो सिचुएशन थी उस हिसाब से लिया है। फिर भी उनकी जो टिप्पणी है उसका भी उसके बारे में हम लोग सोचेंगे और उसके बारे में गवर्नर के जो लॉयर है उसका रिप्लाई करेंगे।
कोर्ट ने कहा कि हम रिलीफ दे देते अगर उद्धव ठाकरे रिजाइन नहीं करते। सबसे बड़ी गलती है उनकी लाइफ की।
हमारा पहला सबमिशन वही था, हमारे सीनियर लॉयर हरीश साल्वे जी का यही सबमिशन था कि माननीय उद्धव ठाकरे जी ने जो रिजाइन किया है उसी वजह से ये केस डिफरेंट है।
उन्होंने कहा एक आखिरी सवाल, मॉरल ग्राउंड पे इस्तीफा दे देना चाहिए, मॉरल ग्राउंड पे इस्तीफा देना चाहिए, मॉरल ग्राउंड पे इस्तीफा दे देना चाहिए,
नहीं क्या
मॉरल ग्राउंड पे सरकार को इस्तीफा दे देना चाहिए?
नहीं, क्यों इस्तीफा देना चाहिए? कॉन्स्टिट्यूशन को फॉलो किया हुआ है और हमारी जो सरकार है वो लोगों ने जो वोटिंग किया है उस हिसाब से सरकार बनी है। लोगों ने शिवसेना भाजपा के नाते सबको वोटिंग जो किया है उस हिसाब से लोगों का मैंडेट है और लोगों को चाहिए कि शिवसेना भाजपा का सरकार होना चाहिए।
धन्यवाद। तो ये थे राहुल शिवाले।
All right, so that's the latest coming in. Like I pointed out, viewers, at this point of time, and what has come down from the court is interesting because both factions will claim victory. The Uddhav faction and the Eknath Shinde faction. The Eknath Shinde faction is very clear that the Supreme Court has stated that the government stays, which is the Eknath Shinde faction government. However, the Uddhav Thackeray faction will claim moral victory in all of this. They will say that it is relief, for Uddhav Thackeray, where practically the whip, the recognized legal whip, is that of the Uddhav Thackeray faction and not of the Eknath Shinde faction. Complicated in terms of the judgment, but interesting in terms of interpretation, because what had gone down in Maharashtra itself was fairly complicated, unprecedented political proceedings that took place. To break it down, viewers, what has happened net in layman terms? Well, the Supreme Court today, relief for the Eknath Shinde faction, said that the Eknath Shinde faction government stays. However, everything that led up to Eknath Shinde being instated as the Chief Minister of Maharashtra, one could interpret it with what the court said was illegal, from the role of the governor, the speaker, the whip, all of that coming into play on that account. We're going to continue to get you the latest in terms of what the political reactions are that are coming in, because understandably the Uddhav faction will now claim moral victory of sorts of what has gone down, and the Eknath Shinde faction already celebrations on, suggesting that now the legality in terms of the government will not be questioned. However, the Uddhav faction has already started making noise that Eknath Shinde needs to step down on moral grounds. In all of this, there's also food for thought. Had Uddhav Thackeray, in a hasty decision, not resigned as the Maharashtra Chief Minister, has it cost him and his party today, and even the Mahavikas Aghadi? The Supreme Court had said if Thackeray had not resigned and faced the floor test, he refused to face the floor test, resigned before that, the court could have reinstated the Thackeray government. Now, invariably, because Uddhav Thackeray stepped down, it's relief for the Shinde government. Despite of whatever the Uddhav Thackeray government might say, the morality of it, whether the Eknath Shinde has any moral standing to continue, ultimately the court has ruled that the current incumbent government will stay. Critical strictures also passed were against the current Maharashtra government as well. We're going to continue to get across to our legal reporters who will break it down. On the role of the governor, the role of the speaker, the official whip is still Sunil Prabhu, which is the Thackeray whip. The whip appointed by Eknath Shinde has been termed illegal. All right, we're going to cut across to our legal reporters who are going to break down on what went down in Supreme Court today. But net viewers, what we can tell you, relief for the Shinde camp. The Eknath Shinde faction continues in government. The Uddhav faction will claim moral victory, but that is what it would be limited to. They're already asking that Eknath Shinde faction step down on multiple accounts, be it the role of the governor, which could be interpreted as illegal, unconstitutional. The chief whip, recognized whip of the party, as the court said, is Sunil Prabhu. I want to cut across to my colleague Anisha Mathur. Anisha, we've been giving breathless commentary on what the court or the Chief Justice of India observed while giving out the judgment. But net, if we have to lay it down in layman terms, it does seem in all of this that it is relief for the Eknath Shinde government. However, the Uddhav faction can claim victory where the Eknath Shinde government stays as per the court. However, what can be interpreted of what went around the making of this government could be illegal.
कुछ नहीं दिखाई दिया बिल्कुल ऐसे पहले नहीं सब मैं करूँ अपने तरीके से आप लोग शांति रखिए पेशेंस कोई नहीं बोलेगा भाई शांत ओके देखिए आप लोग सब बोले जा nobody will speak please if you speak you are delaying yourself please don't speak I will do Hindi English Maharashtra NCT both just be patient for 10 minutes please देखिए आज दो रुक जाओ ना यार ये आप ही के लोगों तो बोलिए ना इन्हीं को बोल रहा हूँ तो अपने लोग ही आपके सब करते नहीं, चलता रहेगा। आवाज जो बोलेगा तो हो ही नहीं पाएगा।
भाई साहब
जब तक आप बोलेंगे शुरू नहीं हो सकता।
आप ठीक है, चलिए।
भाइयों और बहनों, आज संविधान पीठ के दो अत्यंत महत्वपूर्ण निर्णय आए हैं। संविधान पीठ ने विस्तृत रूप से सब अपने निष्कर्ष लिखे हैं कारणों के साथ। महाराष्ट्र के विषय में जितने भी मूल मुद्दे हैं कानून के, वो हमारे पक्ष में हुए हैं। राज्यपाल का निर्णय गलत है। उन्होंने ऐसे तथ्यों को देखा जो नहीं थे वहां पर, जो वो नहीं देख सकते थे। राज्यपाल का निर्णय को गलत करार किया गया। स्पीकर का निर्णय, जिन्होंने किसी और की विप को ऊपर आधार पर अपना निर्णय किया, उसको गलत माना है। विप गोगावले के नियुक्ति को गलत माना है। ये कहा है कि विप सिर्फ राजनीतिक पार्टी की हो सकती है, न कि वो विधायिका पार्टी की हो। तो हर महत्वपूर्ण कानूनी मुद्दे पे सत्य की विजय हुई है। हम नमन करते हैं उच्चतम न्यायालय को। ये बात सही है कि माननीय उद्धव ठाकरे जो उस वक्त मुख्यमंत्री थे, उन्होंने इस्तीफा दिया, इसलिए उनको रिलीफ नहीं दी। लेकिन आज सबसे महत्वपूर्ण निष्कर्ष क्या है कि माननीय स्पीकर को तुरंत निर्णय करना है कम समय में डिस्क्वालिफिकेशन पिटीशन का। तो मैं आपसे एक प्रश्न पूछना चाहता हूं कि डिस्क्वालिफिकेशन पिटीशन का निर्णय तो एक ही हो सकता है। उन्होंने विप का अस्वीकारिता की, लोगों ने, उन्होंने विप का उल्लंघन किया। तो जब आपने विप का उल्लंघन किया तो क्या बचा? माननीय स्पीकर को तुरंत उस आधार पर डिस्क्वालीफाई करना चाहिए और इसी से न्याय होगा, सत्य की विजय होगी। जहां तक एनसीटी का सवाल है, एक ऐसी सिचुएशन, और ये किसी राजनीतिक पार्टी की बात नहीं है, कल कांग्रेस होगी, आज आप है, कल बीजेपी होगी। आपने दिल्ली को ये स्वरूप दिया जिससे वहां स्वायत्व हो, यहां पर ऑटोनॉमी हो। आज स्वायत्त और दिल्ली की विजय है। दिल्ली के हर उस तौर तरीके से जिसमें केंद्र सरकार ने गलत रूप से हस्तक्षेप किया है, उसको निरस्त किया गया है इस निर्णय द्वारा। और इसमें हर पक्ष में कोई सिंगल ऐसा पक्ष नहीं है, मुझे सौभाग्य था इसका दलील करने का, और कोई हमारा ऐसा पक्ष नहीं है जिसको मना किया गया हो। मैं समझता हूं कि जो सर्विसेज हैं, जो यहाँ के काम हैं, अब बिना अवरुद्ध होने के, बिना उल्लंघन के, बिना विलंब के, बिना
You had Abhishek Manu Singhvi there talking about the two very, very important decisions, judgments that have come in from the Supreme Court. The Chief Justice of India unanimously read out both in one. Of course, a big win coming in for the Aam Aadmi Party, for Arvind Kejriwal, for Delhi. On the other hand, a verdict which both factions, I would reckon, be it the Shinde faction or the Uddhav faction in Maharashtra, will claim victory. At one end, there will be Eknath Shinde faction, which will say that, listen, the court has made it very clear that the incumbent government says. On the other hand, the Uddhav faction will claim moral victory. Not just moral victory, you just heard Abhishek Manu Singhvi there stating very clearly that now, after what the court has stated in terms of the chief whip, the recognized legal whip of being Mr. Sunil Prabhu of the Uddhav faction, the speaker needs to be morally compelled to disqualify the MLAs. All right, let's cut across to the latest reactions coming in right now.
शिवसेना के वरिष्ठ नेता विनायक राउत इस वक्त हमारे साथ मौजूद हैं। सुप्रीम कोर्ट ने आज जो फैसला दिया है, खासकर कि जो स्पीकर के रोल पे और गवर्नर के रोल पे जो उन्होंने कमेंट्स दिए हैं, उसको आप कैसे देखते हैं?
मैं बहुत मुझे खुश हुई कि इस देश के जो सर्वोच्च न्यायालय, उन्होंने राजकीय हेतु से अनियमित काम करने वाले राज्यपालों को बहुत बड़ा सबक सिखाया है। मैं जानता हूं कि भविष्य में पूरे देश में ऐसे राजनीति करने वाले लोग राज्यपाल के ऊपर नहीं बैठेंगे।
एक बड़ा सवाल है, ये कहा कोर्ट ने कि अगर उद्धव ठाकरे ने इस्तीफा नहीं दिया होता तब शायद हम राहत देते।
हमें उसका कुछ गम नहीं है। जो किया उद्धव साहब ने अपने दिल से किया है, इसके लिए कुर्सी पे बैठने का उनका कोई स्वार्थ नहीं था।
सरकार से आप इस्तीफा मांग रहे हैं? आप
इस्तीफा तो जरूर मांगूंगा, इस्तीफा तो जरूर मांगूंगा। जिस तरीके से सर्वोच्च न्यायालय ने व्हिप के बारे में, गवर्नर के बारे में जो अपना निर्णय दे चुका है, इसके साफ पूरा साबित हो रहा है कि अभी एक क्षण भी ये सारे महाराष्ट्र गवर्नमेंट के मुख्यमंत्री।
Let's cut across to get the latest reaction. I have Mr. Rahul Narwekar, Speaker of the current incumbent government. He's on this phone line with us. Mr. Narwekar, what do you make? There seems to be moral pressure right now that the disqualification actually takes place. That is what the Uddhav faction is asking.
See, there is the judgment of this Honorable Supreme Court has just been delivered. They have given their ruling on various issues. I understand from the judgment is, number one, the Honorable Supreme Court has made it abundantly clear, absolutely clear, that it is only the Speaker who will decide the disqualification petitions. Number two, they have mentioned that the decision of recognizing the whip should be based on what the political party has stated and not what the legislature party has stated. Therefore, the whip appointed by the political party should be considered to be the right appointment. And three, they have further gone to say that in the present scenario, in June 2022, June-July 2022, who represented the political party is to be determined by the Speaker after conducting an in-detail inquiry. And therefore, these are three very important issues which the court has ruled on. With regards to the governor's role, they have made it absolutely clear that that is only academic, and in the facts of the case, no reliefs can be granted based on that decision of the court. And therefore, it is now for the Speaker to take a decision on the disqualification based on recognition as to who really represented the political party at the relevant point of time.
Lots of observations are also made in terms of the current whip of the legal whip, recognized whip of being Mr. Sunil Prabhu of the UBT faction, which was of course the Uddhav Thackeray faction, the Shiv Sena at that point of time, and calling the appointment of Bharat Gogavle as illegal.
See, please appreciate that the Schedule 10 as it stands, there is no clear direction given as to whether it is the political party or it is the legislature party who appoints the whip and who decides. Because at the end of the day, the legislature party is a creation of the political party itself. And now that the court has given a clarification and clear interpretation of the provisions, they have ruled that it is the political party who should decide the whip. Now that being the case, we will decide it accordingly. But at the relevant point, there was no clear guideline under Schedule 10. Otherwise, we would have taken those guidelines.
But Mr. Narwekar, Mr. Narwekar, the instruction is also that the Speaker has to take decision very quickly on the disqualification of the 16 MLAs of the Shinde faction. Now, this is what the Uddhav faction says in collaboration with the fact that the appointment of Bharat Gogavle has been deemed illegal by the crop court.
Please appreciate that this court at no point of time has given a timeline for deciding, although it will be the endeavorance of the Speaker to decide it at the earliest possible moment. However, before deciding, there are various other exercises which the Speaker has to carry out. Prima facie, preliminarily, he will have to first decide as to who was in control of the political party at the relevant time. Thereafter, he will have to decide the petition based on merit, where all the provisions of CPC are applicable. There will be everyone under principles of natural justice will have to be given an opportunity to put forth their case. There will be examination, evidence-led. There will be cross-examination, examination in chief. The entire process will have to be carried out.
The entire process will have to be carried out, sir, but now there is going to be mounting moral pressure at least, where the Uddhav faction is concerned that the speaker does constitutionally the right thing.
Speaker has always constitutionally done the right thing. I would like to clarify very clearly that the Speaker at no point of time has done anything that is unconstitutional. And therefore, for anyone to assume that the Speaker won't do anything, something which is constitutional, is completely out of line. Let me assure you and your viewers that the Speaker's office is a neutral office. The Speaker's office is apartisan, and we shall abide by our constitutional duties to the T. And there is no question about that.
You know, Mr. Narwekar, if you stay with us, because in terms of interpretation of the role of the Speaker, primarily also right now, the recognition of the legal whip as Mr. Sunil Prabhu of the Uddhav Thackeray faction, and the bearing of the Speaker then, which of course no time limit has been given, but the court did say quickly that decision needs to be made by the Speaker. I just want to pull in, because it seems that there seems to be a little discrepancy how you're reading the judgment and what exactly the judgment is. I want to bring in Anisha Mathur, my colleague, to elucidate that. Anisha, in what context did the top court of the country today state that Mr. Sunil Prabhu is the recognized legal whip and the appointment of Mr. Govt is illegal, A, and on the role of the Speaker, was any time frame given that the decision on disqualification needs to be made?
Well, Preeti, to answer both of your questions, the court has gone into the legality of who exactly can appoint the whip. Now, the court has very clearly held, and this is where Uddhav faction is claiming a huge victory, that the Speaker could not have accepted the whip appointed by a rebel faction, that the whip is only appointed by the political party, which at that time was led by Mr. Uddhav Thackeray, which means that Mr. Sunil Prabhu was the recognized whip of the party. Now, second point that it comes to is that if the whip is violated, then what happens? Now, the court has said that the Speaker will have to consider the disqualification petitions of the what we've been saying rebel MLAs with regard to the situation which was then prevailing, which means that the Speaker now will have to consider what was the situation then when Mr.
Exactly.
Sunil Prabhu's
Stay
whip
with
was
me,
violated.
stay with me, stay with me, Anisha, stay with me. We have Mr. Narwekar with us. Mr. Narwekar, all right, we seem to have lost Mr. Narwekar, who was under the assumption that the Speaker would have to take decisions on where the Assembly is right now in terms of the current constitution of the Assembly. But Anisha, continue, with what you were stating, that the Speaker would have to look at the situation then on what the composition was at that point of time and then move ahead. Go ahead, Anisha.
Well, Preeti, just to clarify, this is something that the court has said, that since there is clearly been held by the court that the decision of the Speaker as well as the decisions of the Governor were taken on basis of incorrect.
Thus, let's listen in to Mr. Narwekar.
पॉलिटिकल पार्टी का विप एप्लीकेबल होना चाहिए, तब ये भी उन्होंने आगे कहा है कि पॉलिटिकल पार्टी कौन रिप्रेजेंट करता है, इस बारे में भी निर्णय ये अध्यक्ष को लेना है।
नहीं, लेकिन आज की स्थिति में जब आप पुराने चीज पर फैसला लेंगे, जो घटनाएं जून महीने में हुई थी 2022 में, जब उद्धव ठाकरे राजनीतिक पार्टी के नेता के रूप में मौजूद थे, तब क्या अब आप उस वक्त के फैसले के आधार पर अब फैसला आप लेंगे, या नए सिरे से आप इसको देखेंगे? किस तरीके से आपका आगे का हियरिंग होने वाला है?
सुप्रीम कोर्ट ने कहा है कि इन डिटेल इंक्वायरी करके उस समय पॉलिटिकल पार्टी कौन रिप्रेजेंट कर रहा था, इस विषय के भी पूरी मालूमात, केवल ऐसा कभी नहीं कहा है सुप्रीम कोर्ट ने कि उस समय केवल उद्धव ठाकरे या केवल एकनाथ शिंदे जी पॉलिटिकल पार्टी के प्रेसिडेंट थे या रिप्रेजेंट कर रहे थे।
नहीं, लेकिन सर भरत गोगावले को प्रतोद मांगना, सर
पहले डिसाइड करना है कि पॉलिटिकल पार्टी कौन रिप्रेजेंट करती पार्टी है, कौन करता है?
Sir, if I may quote what Chief Justice Chandrachud said, चंद्रचूड़ सर ने ये बात अपने जजमेंट में कही है कि भरत गोगावले की को विप मानना ये गलत था, ये बात उन्होंने कही है। यानी कहीं ना कहीं आपने जो भरत गोगावले को विप माना वो गलत है, ये बात उन्होंने इसमें अपने प्रोनाउंसिएशन में।
मैं आपके बात से और सुप्रीम कोर्ट की जो आपने इंटरप्रिटेशन किया, आपने जो सुप्रीम कोर्ट के जजमेंट की इंटरप्रिटेशन की है, उससे मैं सहमत नहीं हूँ। सुप्रीम कोर्ट ने ये कहा है कि पॉलिटिकल पार्टी जो विप पॉइंट मानना चाहिए, स्पीकर ने पार्टी का विप मानना चाहिए, तो उन्होंने ये रूलिंग दी है। अभी भरत गोगावले को जिन्होंने नियुक्त किया है।
जी राहुल जी, आपकी आवाज कट रही है दोबारा। राहुल जी, राहुल जी, राहुल जी, आपको आवाज आ रही?
जी, मुझे आवाज आपकी आ रही है।
हाँ,
आपको आ रही है मेरी आवाज?
जी जी, बताइए।
सुप्रीम कोर्ट ने केवल इतना कहा है कि यदि भरत गोगावले को आपने विप अपॉइंट किया है केवल इस आधार पर कि वो लेजिस्लेचर पार्टी के अपॉइंटेड विप है, तो वो सही नहीं रहेगा।
करेक्ट।
आपको पॉलिटिकल पार्टी का डायरेक्शन मानना पड़ेगा।
जी।
उसके बाद उन्होंने ये कहा है कि तत्कालीन पॉलिटिकल पार्टी किसके कंट्रोल में थी और तत्कालीन पॉलिटिकल पार्टी कौन चला रहा था, ये निर्णय भी आपको लेना है फैक्ट्स के बेसिस पे, इंक्वायरी के बेसिस पे।
जी।
पहले तो हमें ये तय करना पड़ेगा कि उस समय यानी 2022 नवंबर में 2022
जून जुलाई में पॉलिटिकल पार्टी
कौन चला रहा था, मेजॉरिटी किसके साथ थी, ये पहले तय करना पड़ेगा। और उसके बाद तय करना पड़ेगा विप इशू किया गया था वो सही था या नहीं। तो भरत गोगावले यदि केवल लेजिस्लेचर पार्टी के इशू ऑथोराइज विप है, इसीलिए उनको विप मानना शायद गलत होगा, ये बात सुप्रीम कोर्ट ने कही है। लेकिन उसके बाद उन्होंने क्लियरली कहा है कि पॉलिटिकल पार्टी ने इशू किया हुआ विप विल बी द राइट विप। ये विप पॉलिटिकल पार्टी कौन एग्जैक्टली रिप्रेजेंट करता है, ये स्पीकर ने पहले तय करना है और उसके बाद आगे बढ़ना है। तो इसीलिए मैं नहीं समझता हूँ इसमें कोई फंडामेंटल एरर या फिर इलीगैलिटी थी। इसमें केवल इंटरप्रिटेशन आज जो सुप्रीम कोर्ट ने दिया है शेड्यूल 10 का, उसके आधार पर अभी हमें निर्णय लेना है। दूसरी बात, शेड्यूल 10 में ये कहीं भी नहीं कहा गया था अनएम्बिग्यूअसली कि पॉलिटिकल पार्टी का विप एप्लीकेबल होगा या लेजिस्लेचर पार्टी का। यदि ये अनएम्बिग्यूअसली स्टेटेड रहता तो निर्णय कुछ और लेने का कोई सवाल ही नहीं आता। आज जब इंटरप्रिटेशन आ गया है सुप्रीम कोर्ट का, तब हम निश्चित रूप से उस आधार पर निर्णय ले सकते हैं।
नहीं तो अभी कितना समय इसके लिए लग सकता है? क्या आप दोबारा सुनवाई करेंगे? क्या दोबारा आप फैक्ट्स को चेक करेंगे? कोई टाइम बाउंड? जी
देखिए, स्टार्टिंग पॉइंट तो ये है कि पॉलिटिकल पार्टी कौन है ये तय करना स्टार्टिंग पॉइंट है।
तो जून 2022 में शिवसेना राजनीतिक पार्टी का अध्यक्ष कौन था, कौन वो पॉलिटिकल पार्टी चला रहा था, वो आप
तो अब हम तस्वीरें आपको दिखा रहे हैं कि
इधर have lost that connection with Sahil Joshi and Rahul Narwekar, but interesting, where Rahul Narwekar spoke with us a short while back, and he says, okay, these are live shots coming in. Nitish Kumar, Tejashwi Yadav, the emissaries of a united opposition, now going across and meeting Uddhav Thackeray and Aditya Thackeray there, putting a shawl around Nitish Kumar, flanked by Sanjay Raut. Images coming in at the point of time where, of course, Uddhav Thackeray, at his account, will claim moral victory. The Shinde faction will say that, listen, the end game is we stay, our government stays. And there is no question about illegality of the government. But these visuals will also go down a long way. Nitish Kumar, Tejashwi, giving out the perfect picture of, one might suggest, with Uddhav Thackeray of trying to get in as many opposition parties, opposition leaders on board of building a coalition of sorts together against the BJP moving ahead to 2024. Nitish Kumar, Tejashwi have been hopping from state to state, from opposition leader to leader, trying to build consensus. It all started with both of them meeting Rahul Gandhi, Sonia Gandhi in the national capital, and from there on, Nitish Kumar has been on a whirlwind of sorts, meeting the Aam Aadmi Party Chief Minister Mamata Banerjee just about 2 days ago, Naveen Patnaik from Odisha. Yesterday, he held a press conference with Mr. Soren in Jharkhand. He's already in talks with KCR where Telangana is concerned, and now speaking with Uddhav Thackeray, and that photo opportunity there with Nitish Kumar meeting Uddhav Thackeray in Maharashtra. Will he also be meeting NCP Chief Sharad Pawar? Interesting. But all of these visuals coming together, trying to build a coalition where at least there seems to be an understanding that has gone down between the Chief Minister of Bihar, Mr. Nitish Kumar, and the Congress High Command, that the Congress is going to try and approach those political parties amiable to the Congress, where they have a direct line with. And those who haven't been, not on the same page as the Congress, or a little antagonist where the Congress is concerned, will be the political parties in states where Nitish Kumar will go as an emissary and try and build consensus. He seemed to have done so in Delhi with Arvind Kejriwal, Aam Aadmi Party, the Congress not quite on the same page, and rivals in states like Punjab and Delhi. But Nitish Kumar trying to broker a bridge there, even with the TMC, where he went and met Mamata Banerjee. Mamata Banerjee had been highly critical of the Congress of late, but seemed to have subdued, and especially after her talk with Nitish Kumar, it seems TMC also on board. But let's listen in. Uddhav Thackeray speaking.
मुख्यमंत्री आणि उपमुख्यमंत्री नितीशजी आणि तेजस्वीजी हे पहिल्या प्रथम आलेले आहेत, आणि लढवय्या शब्द वापरल्यानंतर इथे त्यांचा येण्याचा हेतू हा आपल्याला सगळ्यांना कळला असेल. देशामध्ये एकूणच लोकशाहीची हत्या होते की काय असं चित्र दिसतंय, आणि लोकशाही वाचवण्यासाठी सर्वच, नुसते मी विरोधी हा शब्द नाही वापरणार, तर विरोधी कोणाचे विरोधी, तर जे लोकशाहीची हत्या करू इच्छितात त्यांचे विरोधी, असे सगळे देशप्रेमी पक्ष आणि जनता एकत्र करण्याचे जे आमचे प्रयत्न सुरू आहेत, ते प्रयत्न आणखी बळकट करण्यासाठी नितीशजी आणि तेजस्वीजी आणि त्यांच्या सोबत त्यांचे सगळे सहकारी आलेले आहेत. त्यांचं सगळ्यांचं मी स्वागत करतोय. आजच सर्वोच्च न्यायालयाचा निकाल सुद्धा आलेला आहे, आणि मला खरंच एका गोष्टीचं समाधान आहे. मी वारंवार असं म्हटलं होतं की सर्वोच्च न्यायालयाचा निकाल हा केवळ शिवसेनेच्या भवितव्याचा नसेल, तर तो आपल्या देशातल्या लोकशाहीच्या बद्दल, लोकशाही जिवंत राहणार की नाही याबद्दलचा असेल.
This is a decision not just about Shiv Sena, but about our democracy.
त्याच्यामध्ये एकूणच सत्तेसाठी हपापलेल्या लोकांचं उघडं नागडं राजकारण हे त्यांनी त्याची पूर्णपणाने चिरफाड केलेली आहे. सगळ्यात महत्त्वाचं म्हणजे राज्यपाल महोदयांची जी भूमिका होती ती संशयास्पद, आता त्या संशयास्पद म्हणायला सुद्धा काही अर्थ राहिलेला नाही. ती सरळ सरळ अयोग्य होती, आणि एकूणच राज्यपालांच्या सुद्धा वस्त्रहरण झालेलं आहे. मग ते दिल्लीच्या बाबतीत असेल, इथल्या बाबतीत असेल. आणि राज्यपाल ही यंत्रणा ही एक आतापर्यंत आदरयुक्त अशी यंत्रणा होती, पण राज्यपाल यंत्रणेचे धिंडवडे ज्या पद्धतीने शासनकर्ते काढतायत ते बघितल्यानंतर आता याच्या पुढे राज्यपाल यंत्रणा ही अस्तित्वात ठेवावी की नाही, हा सुद्धा एक मोठा विचार मला असं वाटतं सर्वोच्च न्यायालयापुढे आपल्याला
Supreme Court should consider if the office of the governor should exist at all.
राज्यपालांना अधिवेशन बोलवण्याचा अधिकार नव्हता, त्यांनी बोलवण्याची गरज नव्हती, वगैरे वगैरे सगळे आता आपण डिटेलमध्ये गेल्यानंतर
Supreme Court has said that governor didn't have the right to call for a protest.
त्यांनी अध्यक्षांवरती जरी सोपवला असला तरी पक्षादेश हा त्यावेळेचा जो पक्ष म्हणजे माझी शिवसेना त्या शिवसेनेचाच राहील. आता अध्यक्ष महोदयांना सुद्धा ह्याच्यामध्ये वेळ न काढता लवकरात लवकर निर्णय घ्यावा याच्यासाठी आम्ही आता मागणी
This will be our request that the party stays with us the Shiv Sena.
कर ही रहा हूँ और लड़ाई तो आज शुरुआत हो गई है। मैंने जैसे अभी आपको कहा, जब हम अंदर बात कर रहे थे तो एक ज्याला शुभ शकुन असं म्हणतो कि इतने दिनों से हमारी लड़ाई चल रही थी सर्वोच्च न्यायालय में, आज आप भी आ गए और वो निर्णय भी आ गया। इस देश में अब प्रजातंत्र, उसकी रक्षा करना हमारा काम है। जैसे सर्वोच्च न्यायालय ने कहा कि अगर मैं रिजाइन नहीं करता, मैं इस्तीफा नहीं देता, तो शायद मैं वापस मुख्यमंत्री बन जाता। मैं मेरे लिए नहीं लड़ रहा हूँ, मेरी लड़ाई जनता के लिए है, मेरे देश के लिए, मेरे राज्य के लिए है। और भले हम इसके पहले राजनीति में विवाद तो होते रहते हैं, लेकिन एक मत तो हमारा हो गया है कि इस देश को हमें बचाना है, संविधान को बचाया है। और इसलिए आप यहाँ आए हैं, हम मिलकर पूरे, आप तो पूरे देश में घूम रहे हैं, सबके घर जा रहे हैं, हम सब मिलकर ये जो अपने देश को फिर से एक बार गुलाम बनाना चाहते हैं, उनको घर भेजेंगे। और मुझे पक्का भरोसा है पूरी जनता हमारा इंतजार कर रही है।
राजीनामा देण्याची चूक झाली असं वाटतं का?
तो आपने तो बात बता ही दिया है, सब लोग तो आए ही हुए हैं इनसे मिलने के लिए। बातचीत तो होती रहती थी, लेकिन ये तय था कि एक दिन लोग आएंगे। इन्होंने आज ही का समय दिया और आज जो इनका मामला था, जिसके बारे में जानते ही हैं, इनके साथ जो अन्याय हुआ था, अब जिस तरह से जो फैसला आ गया तो बहुत अच्छा हुआ है। तो इन्होंने खुद ही बता ही दिया है। और किसी भी प्रकार से, एक तो आश्चर्य की बात है कि पार्टी के नाम को कैसे कोई बदल सकता है। तो इन सब चीजों को लेकर के तो हम लोग सब दिन तो अपनी बात अपना इनके साथ हम लोग रही हैं, लेकिन अभी जो हम लोग आए हुए हैं उसका मकसद इन्होंने बता दिया। हम लोग चाहते हैं कि पूरे देश में अधिक से अधिक पार्टियां एकजुट हों और मिल करके हम लोग लड़ेंगे। तो आज जो केंद्र में हैं वो पूरे देश के लिए कोई काम नहीं कर रहे हैं और समझ लीजिए इतिहास बदल रहा है। इसलिए इन सब चीजों को देखते हुए अपने देश के हित में और आजादी की लड़ाई हुई और किस तरह से देश आजाद हुआ है और कितना ज्यादा काम होता रहा है पहले से, काम तो करते नहीं। अब आप सब लोग मीडिया के साथी, हम आपका नमन करते हैं, आपके हम खिलाफ नहीं कुछ बोल सकते, लेकिन हम जानते हैं ना कि आप लोगों के ऊपर भी किस तरह से किया है कब्जा। कि कोई बात तो थोड़ा बहुत आप कह दीजिएगा, लेकिन ज्यादातर वो लोग अपनी तरफ से प्रचार करवा रहे हैं। काम क्या कर रहे हैं देश में बताइए? कहीं कोई काम हो रहा? और अलग अलग राज्यों में दूसरे पार्टी के लोगों ने जो काम किया है उसके बारे में तो उतना चर्चा भी नहीं होता। तो इसीलिए देश के हित में जरूरी है कि भाई देश आगे बढ़े और आपस में किसी तरह का विवाद नहीं होना चाहिए। कोशिश क्या हो रही है? समाज में एक तरह का विवाद पैदा हो और ये नहीं होना चाहिए। सब में एकता, हिंदू मुस्लिम कोई भी जाति के हों, सब में कोई विवाद नहीं होना चाहिए, एकता रहनी चाहिए। तो हम लोग तो यही चाहते हैं कि ज्यादा से ज्यादा पार्टियां एक साथ मिल करके काम करेंगी। और इस बीच में बहुत लोगों से बातचीत हो गई है। आज तो इनसे ऐसे हमारी बातचीत हम लोगों की होती रहती ही है, आज भी बात करेंगे। अब इसके बाद ये तय होगा कि कब मीटिंग सब लोगों की होनी। तो अभी तो एक राउंड आप जानते ही हैं, पिछले महीने भी हम लोगों ने बातचीत किया और जिस तरह से बातचीत हुई है अनेक पार्टियों से, बहुत लोगों से बहुत अच्छी बातचीत हो गई है। अब उसके बाद आगे जो करना होगा वो हम लोग करेंगे। लेकिन अभी तो आए हैं, बस यही मकसद है इनका और हम लोगों का विचार तो एक ही है ना, भाई देश के हित में काम करेंगे। कोई तरह से जो हमारा पुराना इतिहास है देश का उसको बिल्कुल कायम रखेंगे। तो ये सब चीजों के लिए करेंगे। इन लोग को अपना कर रहे हैं ना, इन लोग आजादी की लड़ाई से क्या मतलब था, इनको कोई मतलब नहीं। अब वो सोच लीजिए कितना कोई काम हो रहा है, अपने अपने ढंग से नई नई चीजों का नामकरण कुछ भी होते रहता है। ये तो विचित्र बात है। तो इसीलिए जरूरत इस बात की है कि एकदम पूरे देश को एकजुट करना है और आगे बढ़ाना है। तो अगर सभी लोग एकजुट होकर के करेंगे और उनका जब मुकाबला होगा अगले साल के चुनाव में, लोकसभा के चुनाव में, तो खूब अच्छी तरह से सफलता इधर मिलेगी और फिर देश सही दिशा में आगे बढ़ जाएगा।
सवाल इसके दो पक्ष हैं। पहला पक्ष यह है, आपने कहा लड़ाई में अकेले नहीं लड़ रहा हूँ, मैं जनता के लिए लड़ रहा हूँ। मेरा सवाल यहाँ से इसके दो पक्ष ये है कि पहला तो ये कि क्या अगर आप उस वक्त इस्तीफा नहीं देते तो आज आपकी लड़ाई और ज्यादा मजबूत होकर उभर के सामने आती? पहला
मैं मानता हूँ, देखो इसके जिस नजरिया से आप देखते हो, ठीक है, कानूनी तौर पर मैंने इस्तीफा दिया, शायद गलत हो सकता है, लेकिन नैतिकता अगर देखे तो जिन लोगों को मेरे पिताजी ने, मेरे पार्टी ने सब कुछ दिया, वो लोग उठकर मेरे ऊपर उंगलियां उठाए, तो उनके लिए मैं मेरा विश्वास या अविश्वास क्यों जताने की कोशिश करूं? तो ऐसे लोगों को अधिकार ही नहीं है मुझे सवाल पूछने का। जिन लोगों ने मेरे पार्टी से सब कुछ लिया और गद्दारी की, तो गद्दार लोग मेरे ऊपर अविश्वास लाए और उसका मैं सामना करूं, कैसे हो सकता है? ये तो गद्दार लोग हैं। आज तो कोर्ट ने कहा, और मतलब कोर्ट ने गद्दार नहीं किया, लेकिन ये सारी बातें हैं। आज तो मतलब महाराष्ट्र में अब सरकार ही नहीं है। नैतिकता तो अभी जैसे मैंने नैतिकता का पालन किया, तो अगर इस मुख्यमंत्री में जरा भी कोई नैतिकता होगी तो मुख्यमंत्री और उप मुख्यमंत्री ने इस्तीफा देना चाहिए, जैसे मैंने दिया।
महाविकास आघाडीमध्ये सुद्धा जे सर्व प्रमुख नेते होते त्यांनी तुम्हाला म्हटलं होतं की राजीनामा देऊ नका, आपण फ्लोअर टेस्टला सामोरं जाऊ. तुम्ही भावनिक राजकारणाला महत्व दिलं
नाही. मी असेल तो कदाचित आमच्या घराण्याचा गुण किंवा दोष असेल, पण मी जे आता म्हटलं की ज्या घरानी, ज्या पक्षांनी ज्यांना सगळं काही दिलं, सगळं काही घेऊन सुद्धा जे माझ्या पाठीत वार करायला निघाले, त्यांनी माझ्यावरती अविश्वास आणावा हे मला काही पटलेलं नाही. म्हणजे एक तर स्वतः गद्दार त्यांनी केला, विश्वासघात करणाऱ्यांकडून मला जर विश्वासदर्शक ठराव, अविश्वासदर्शक ठरावाबद्दल विचारलं जात असेल तर ते अयोग्य आहे.
जिस लड़ाई की आप बात कर रहे हैं, जो मिलकर सामने आए हैं, इनमें इन दोनों का कितना अहम रोल और किस तरह से देखेंगे आप?
अभी क्या रोल, अभी क्या वो सिनेमा या नाटक थोड़ी है कि रोल कैसे रहेगा, ये देखो ऐसा रोल रहेगा. ये रोल तो
जब ये हम लोग ऑपोजिशन यूनिटी की बात करते आ रहे हैं, विपक्ष का चेहरा कौन बनेगा? आपकी कुछ कोशिश?
ठीक है, चलो अभी तो हम इकट्ठा आ रहे हैं.
सबको एकजुट करना चाहते हैं, लेकिन अपना कुछ नहीं करना चाहते हैं, ये जान लीजिए. हम तो सिर्फ चाहते हैं कि सब एकजुट हो, मिल करके सब लोग लड़े और हम लोग मिल करके पूरा का पूरा सिद्धांत बना के चलें और देश को आगे बढ़ाएं. हमको नहीं बनना है, और जो भी बनेंगे वो सब मिलके सबको आगे बढ़ाएंगे.
बिहार में मीटिंग का डेट तय हुआ है. मीटिंग का डेट तय हुआ है बिहार में. बिहार में मीटिंग का डेट बिहार में
बताएंगे.
उद्धव जी
आता तुम्ही जो एक प्रश्न विचारला, सर्वोच्च न्यायालयाने जे काय मला समजलेलं आहे त्यानुसार सांगितलेलं असं आहे की सर्वोच्च न्यायालय याच्या बाबतीत निकाल देऊ शकतो, कारण त्यांचा तो अधिकार आहे. परंतु त्यांनी त्या संस्थेचा एक आदर राखण्यासाठी हा निकाल किंवा हा निर्णय घेण्याचा अधिकार अध्यक्षांकडे जरी दिलेला असला तरी व्हीप पक्षादेश हा तो त्यावेळेला जो पक्ष होता म्हणजे माझी शिवसेना, त्या पक्षाचा पक्षादेशच चालणार आहे.
All right, lots of reaction coming in. We are going to cut across back to Uddhav Thackeray, but let's listen in to Devendra Fadnavis.
आम्ही पूर्ण समाधानी आहोत. या संदर्भात 2 वाजता माननीय मुख्यमंत्र्यांसमवेत प्रेस कॉन्फरन्सला मी उपस्थित राहणार आहे. माननीय मुख्यमंत्र्यांची प्रेस कॉन्फरन्स आहे, त्यामुळे निकालावर अधिक विश्लेषण हे प्रेस कॉन्फरन्समध्ये आम्ही करू. फक्त एवढं सांगतो की जे लोक कालपर्यंत उड्या मारत होते की आज सरकार जाणार, त्यांच्या सगळ्या मनसुब्यांवर पाणी फिरलं गेलेलं आहे. ज्यांनी वेगवेगळ्या चर्चा केल्या त्या चर्चाही किती थोतांड होत्या हेही यातनं पूर्णपणे समोर आलेलं आहे. आता याचं पुढचं सगळं विश्लेषण हे निश्चितपणे 2 वाजताच्या पत्रकार परिषदेमध्ये आम्ही करू. तोपर्यंत आपण मला असं वाटतं वाट पाहू. त्या निकालामुळे आम्ही पूर्ण
All right, it seems Devendra Fadnavis, the Deputy CM of Maharashtra, stating that there's going to be a detailed press conference. But let's listen in back to Uddhav Thackeray.
राज्यपाल म्हणजे स्वतःच्या घरचा चाकर असल्यासारखं वापरण्याची जी पद्धत सुरू झालेली आहे ती पद्धत बघितल्यानंतर राज्यपाल यंत्रणाच आता शिल्लक ठेवावी की नाही हा प्रश्न आता सर्वोच्च न्यायालयाला आम्हाला म्हणजे मला असं वाटतं विचारायला पाहिजे की हे असंच जर का कारण प्रत्येकाचे काम असतं या सर्वोच्च न्यायालयाने केलं तसंच जसं आता मीडिया असतो नितीनजी जे जसं म्हणाले की काही गोष्टी तुम्ही लोकांसमोर आणल्या पाहिजे तर 4 स्तंभ जे म्हणतो हे 4 स्तंभ मजबूत पाहिजेत त्याच्यापैकी जर का एका स्तंभाला वाढवी लागली असेल तर त्या स्तंभाचं रिपेअरिंग हे करणं गरजेचं आहे पण आता महत्वाचा मुद्दा हा आहे की राज्यपाल महोदय तेव्हाचे जे काय होते त्यांनी इकडे जे न करू करायचं ते म्हणजे करायला नको ते करून गेले आता गेल्यानंतर त्यांना सजा काय कारण असं जर का होत राहिलं तर तेव्हाचे राज्यपाल 12 वाजून जातील आणि घरी जाऊन मग म्हणतील येतो संत अग्नी आहे करायचं काय नाही अजिबात नाही अपात्रतेचा निर्णय हा त्यांना ठरवायचा आहे पण जे मी समजलं त्याच्याप्रमाणे त्यांनी फुटीरांचा व्हीप नामंजूर केलेला आहे सर्वोच्च न्यायालयाने त्याच्यामुळे माझ्या शिवसेनेचा
यांच्यावरही कारवाई झाली पाहिजे असं तुमचं म्हणणं आहे का
बिलकुल आहे कारण नाहीतर ही प्रथा आणि हा पायंडा पडेल की त्यावेळेला राज्यपाल म्हणजे नाही तर राज्यपाल काय राज्यपाल ही संस्था म्हटल्यानंतर ती काय कॉम्प्युटर नाहीये त्या व्यक्तीच्या जर का त्याच्या मर्जीप्रमाणे ती यंत्रणा चालायला लागली तर त्या व्यक्तीला किंवा काय जाब हा विचारला गेला पाहिजे नाहीतर तो पायंडा पुढे पडेल आम्हाला काय आमच्या वाजून जायचंय निकाल येईपर्यंत आम्ही आमच्या घरी पोहोचलेलो असू
चिन्ह काढलं पण आज कोर्टाने असं म्हटलेलं आहे निकाल देताना की शिवसेना त्यावर कोणी दावा करू शकणार नाही म्हणजे शिवसेना तुमच्याकडे राहील असं
नक्कीच आहे आणि आमचा आर्ग्युमेंट हेच आहे की निवडणूक आयोगाचं काम हे निवडणूक आयोगाने त्यांच्या चौकटीत केलं पाहिजे निवडणूक आयोग म्हणजे ब्रह्मदेव नाहीये राज्यपाल म्हणजे ब्रह्मदेव तर अजिबातच नाही त्यांना आता राज्यपाल मानायची की नाही ती संस्थाच ठेवायची हाच आता एक विचार त्याची चर्चा झाली पाहिजे पण निवडणूक आयोग हे निवडणुकीपुरतं मर्यादित असतं मतांच्या टक्केवारीवरती एखाद्या पक्षाला मान्यता देणं नोंदणी देणं आणि त्याला निवडणूक चिन्ह देणं हे त्यांचं काम असतं नाव देणं नाव काढणं हे त्यांचं काम नाही आम्ही ते मानणार नाही कारण निवडणूक कदापि शिवसेना हे नाव दुसऱ्याला घटना बाह्य अधिकार आहे कारण नाव धनुष्यबाण आणि हे त्या मतांच्या टक्केवारीवरती ठरवण्याचा अधिकार करायची किंवा निवडणूक आयोगाला आहे जसं आता काही पक्षांची राष्ट्रीय पक्ष म्हणून मान्यता काढली ते तुम्ही मतांच्या टक्केवारीवरती नोंदणी ठरू शकाल पण नाव नाही काढू शकत उद्या मी निवडणूक आयुक्तांचंच नाव बदलून वेगळं काय केलं तर काय होईल
What happens if I decide tomorrow to change the name of the Chief Election Commissioner?
आम्ही काढू देणार नाही आम्ही शिवसेना म्हणूनच राहणार
This can't go on. We won't let it happen.
All right, there you have it. Uddhav Thackeray speaking to the press minutes or an hour after the judgment came in from the Supreme Court. He says, when questioned, that the Supreme Court had stated that if he had not resigned, then there was a chance of reinstating him. But the fact that Uddhav Thackeray has resigned of his own volition and did not face a floor test practically makes it untenable for him to be reinstated by the Supreme Court. Uddhav Thackeray, responding to that, said that he was betrayed by those who helped him most, who the party and his father had helped, and he could not sit and let them decide his fate. So therefore was the reason why he stepped down. Let's listen in to the Speaker, because now the role of the Speaker is going to come into play. The Supreme Court has said that the Speaker of Maharashtra has to make a decision quickly on the 16 MLA's disqualification. On the other hand, the Uddhav faction now putting moral pressure on the Speaker and also on Eknath Shinde to step down. Listen in.
There is the judgment of the Honorable Supreme Court has just been delivered. They have given their ruling on various issues. And the strength of judgment is, number one, the Honorable Supreme Court has made it abundantly clear, absolutely clear, that it is only the Speaker who will decide the disqualification petitions. Number two, they have mentioned that the decision of recognizing the whip should be based on what the political party has stated and not what the legislature party has stated. Therefore, the whip appointed by the political party should be considered to be the right appointment. And three, they have further gone to say that in the present scenario, in June 2022, June-July 2022, who represented the political party is to be determined by the Speaker after conducting an in-detail inquiry. And therefore, these are three very important issues which the court has ruled on. With regards to the governor's role, they have made it absolutely clear that that is only academic, and in the facts of the case, no reliefs can be granted based on that decision of the court. And therefore, it is now for the Speaker to take a decision on the disqualification based on recognition as to who really represented the political party at the relevant point of time.
Lots of observations are also made in terms of the current whip of the legal whip, recognized whip of being Mr. Sunil Prabhu of the UBT faction, which was of course the Uddhav Thackeray faction, the Shiv Sena at that point of time, and calling the appointment of Bharat Gogavle as illegal.
See, please appreciate that the Schedule 10 as it stands, there is no clear direction given as to whether it is the political party or it is the legislature party who appoints the whip and who decides. Because at the end of the day, the legislature party is a creation of the political party itself. And now that the court has given a clarification and clear interpretation of the provisions, they have ruled that it is the political party who should decide the whip. Now that being the case, we will decide it accordingly. But at the relevant point, there was no there was no clear guideline on the Schedule 10. Otherwise, we would have taken those guidelines.
But Mr. Navrekar, Mr. Navrekar, the instruction is also that the Speaker has to take decision very quickly on the disqualification of the 16 MLAs of the Shinde faction. Now, this is what the Uddhav faction says in collaboration with the fact that the appointment of Bharat Gogavle has been deemed illegal by the crop court.
Please appreciate that this court at no point of time has given a timeline for deciding, although it will be the endeavorance of the Speaker to decide it at the earliest possible moment. However, before deciding, there are various other exercises which the Speaker has to carry out. Prima facie, preliminarily, he will have to first decide as to who was in control of the political party at the relevant time. Thereafter, he will have to decide the petition based on merit, where all the provisions of CPC are applicable. There will be everyone under principles of natural justice will have to be given an opportunity to put forth their case. There will be examination, the evidence-led. There will be cross-examination, examination in chief. The entire process will have to be carried out.
The entire process will have to be carried out, sir, but now there is going to be mounting moral pressure, at least, where the Uddhav faction is concerned, that the Speaker does constitutionally the right thing.
Speaker has always constitutionally done the right thing. I would like to clarify very clearly that the Speaker at no point of time has done anything that is unconstitutional. And therefore, for anyone to assume that the Speaker won't do anything, something which is constitutional, is completely out of line. Let me assure you and your viewers that the Speaker's office is a neutral office. The Speaker's office is apartisan, and we shall abide by our constitutional duties to the T, and there is no question about that.
Let's quickly listen in to Devendra Fadnavis, the Deputy Chief Minister of Maharashtra.
त्या निकालामुळे आम्ही पूर्ण समाधानी आहोत. या संदर्भात 2 वाजता माननीय मुख्यमंत्र्यांसमवेत प्रेस कॉन्फरन्सला मी उपस्थित राहणार आहे. माननीय मुख्यमंत्र्यांची प्रेस कॉन्फरन्स आहे, त्यामुळे निकालावर अधिक विश्लेषण हे प्रेस कॉन्फरन्समध्ये आम्ही करू. फक्त एवढं सांगतो की जे लोक कालपर्यंत उड्या मारत होते की आज सरकार जाणार, त्यांच्या सगळ्या मनसुब्यांवर पाणी फेरलं गेलेलं आहे. ज्यांनी वेगवेगळ्या चर्चा केल्या त्या चर्चाही किती थोतांड होत्या हेही यातनं पूर्णपणे समोर आलेलं आहे. आता याचं पुढचं सगळं विश्लेषण हे निश्चितपणे 2 वाजताच्या पत्रकार परिषदेमध्ये आम्ही करू. तोपर्यंत आपण मला असं वाटतं वाट पाहावी.
All right, the Deputy Chief Minister making it very clear that any conspiracy to pull down the government has failed, and this is now a legal government, hitting out at the Uddhav faction as well. But a lot going down, viewers. Trust it not to go down so calmly. What you heard was a press conference by Uddhav Thackeray where he stated that what has transpired, he's saying in terms of what the Supreme Court has said, that he's very, very happy with the Supreme Court judgment, and morally this government has lost the right to rule. Listen in to all the other reactions coming in.
एक बात है कि यहाँ पे जो लोगों के मन की सरकार थी, वो सरकार सुप्रीम कोर्ट ने उसको यहाँ पे बचाया है. निश्चित तौर पर विकास के लिए ये सरकार का यहाँ पे रहना बहुत जरूरी था. मैं ये सुप्रीम कोर्ट के निर्णय का स्वागत करता हूँ. ये तो सुप्रीम कोर्ट ने जो दिया है आज, इसका मैंने वही कहा कि अभी इसके ऊपर जो विधानसभा का अध्यक्ष जो है वही निर्णय जो सुप्रीम कोर्ट का आया है इसका स्टडी करके वही कुछ बता सकेंगे. उसके निर्णय के ऊपर मैं कुछ टिप्पणी करूं तो मैं उसके लिए सक्षम नहीं हूं, और राज्यपाल के निर्णय के ऊपर भी मैं क्या टिप्पणी कर सकता हूं.
आज एक बहुत महत्वपूर्ण निर्णय माननीय सर्वोच्च न्यायालय ने दिया है जिसका इंतजार पूरे देश को था, महाराष्ट्र को ही नहीं. और एक अच्छा निर्णय, मुझे ऐसा लगता है कि डेमोक्रेसी में हम लोग कहते हैं कि जिसके पास मेजॉरिटी है तो वही सही होता है. तो आज देखो उद्धव जी को छोड़कर जब 55 में से 41 एमएलए जब निकल जाते हैं तो उनके पास 14 एमएलए बचे हुए थे. बिल्कुल सीधी बात है, क्योंकि उनके हाथ से पूरी पार्टी निकल गई थी, उनका वहाँ कुछ बचा भी नहीं था. और उसके बाद तो उन्होंने रिजाइन भी कर दिया था. अब रिजाइन देने के बाद में वो कहेंगे कि भाई हमारी सरकार हम ही लीगल है, तो मुझे लगता है ये बहुत गलत बात थी.
The Governor's Act of calling for a flow test, which is unconstitutional, illegal, going beyond his authority. It's not just a moral victory. It's a victory of India's constitution. Now it is now in the domain of the Speaker of the House to ensure that those whose disqualification we seek is heard by him, by the chief whip appointed by us, which is Sunil Kabni. And I do not think that the decision on this particular instance of not ensuring the status quo ante was something that we were really fighting for. What we were fighting for was the illegality of everything the governor was doing, illegality of the decision of conducting a flow test, illegality of these MLAs appointing a chief whip and leader of the house, and that has been upheld by the Supreme Court.
उसका ही मतलब है अभी की सरकार गैर कानूनी है. अगर सुप्रीम कोर्ट ये कहते हैं कि अगर उद्धव जी ने नैतिकता के आधार पर रिजाइन किया है, इस्तीफा नहीं देते, तो आज हम उस स्थिति में होते कि उद्धव ठाकरे जी को मुख्यमंत्री के तौर पर फिर एक बार स्थापित करते. उसका मतलब है जिस तरह से सरकार नई सरकार बनाई ये पूरी तरह से गैर कानूनी है और संविधान के खिलाफ बनी है. दूसरी बात सर्वोच्च न्यायालय ने जो कहा है कि शिवसेना,
उस पर हम समाधान व्यक्त करते हैं. 2 बजे माननीय मुख्यमंत्री जी और मैं इस विषय पर प्रेस कॉन्फ्रेंस करेंगे. उस समय इसका पूरा विश्लेषण करेंगे. किंतु जो लोग सुप्रीम कोर्ट के निर्णय पर स्पेक्युलेशन करते हुए हमारी सरकार जाएगी ऐसा कहते थे, आज उनको उसका जवाब मिल गया है. हम लोग इसके ऊपर विस्तार के साथ 2 बजे बोलेंगे. आज नवी मुंबई आयुक्तालयाच्या अंतर्गत अतिशय चांगला कार्यक्रम झाला. महिलांकरता सावली अशा प्रकारचं एक इमारत जी निर्माण झाली आहे, याच्यामध्ये सायबर क्राईमच्या संदर्भातली सायबर लॅब, महिलांकरता समुपदेशन केंद्र,
All right, minutes from now, the Deputy Chief Minister will be holding a press conference. Trust us to get you all sides. As of now, both factions, be it the Uddhav faction or the Eknath Shinde faction are claiming a victory of what has gone down in court, but net Uddhav faction can claim only moral victory for now. The Eknath Shinde faction's government stays as per the court, and the top court also stated that the onus of that practically lies on Uddhav Thackeray. He should not have quit and faced the floor test. Getting you all angles of the story on the other side with my colleague Akshita. Do stay tuned.
India's #1 reporters in the battlefield from India Today's double engine.
So you're saying that in Karnataka you cannot do Hindu-Muslim politics? Are things getting better around here? Are they getting worse?
To Karnataka's finest reporting team.
What do you wish for the state of Karnataka?
Shettar also has an option.
Mallikarjun Kharge. Reservation has been a hot topic.
Priyanka Gandhi Vadra. Roadshow is a mega hit.
And India's leading national reporters.
How are you looking at politics in Karnataka?
Less polarization, more infrastructure.
Unsparing, unmatched, unrivaled coverage. India Today with Karnataka for Karnataka.
Weather forecast now. Delhi, maximum 40 and minimum 25 degrees. Mumbai, maximum 31 and minimum 28 degrees. Kolkata, maximum 41 and minimum 27 degrees. Bangalore, maximum 31 and minimum 24 degrees. Chennai, maximum 33 and minimum 28 degrees. Hyderabad, maximum 38 and minimum 26 degrees.
Why does this happen? Let me tell you the science behind it.
For more informative videos like this, keep watching India Today News Mo. Make your media plan smarter with India Today Live TV on your connected devices. Amplify your brand with 100 million smart internet viewers. To advertise, mail us at sales@aajtak.com.
Imran's supporters are angry because they believe the army has failed to keep the nation's dignity intact. And now they have taken it upon themselves to punish the army. This is an army barrack in Khyber Pakhtunkhwa which the angry protesters have now brought down. Angry mobs are now attacking the very foundation of Pakistan. The crowds are openly assaulting the soldiers. Gone is the fear of the army. The army, which once used to rule Pakistan with iron fists, is now facing the wrath of common people. Stones are being pelted on army convoys. Abuses are being hurled at soldiers. The mobs did not stop there. The house of the Army General Faisal Nasir, who is accused of attempting to kill Imran twice, was set on fire. In Sargodha city, a monument of former army veterans was demolished by angry mobs. The unrest has also exposed the inner rift within the Pakistan army. A video of Jawans being instigated to revolt against their generals has gone viral on social media.
भाई अपनी नस्लों को क्यों खराब कर रहे हो? तुम्हारी नस्लों के लिए लड़ रहे हैं, वो तुम्हारी नस्ल के लिए लड़ रहे हैं। तुम लोग को शहीद करवा रहे हैं वो लोग, खुद ऊपर बैठे हुए सारे, खुद ऊपर है, खुद ऊपर है। तुम शहीद होते हो, बॉर्डरों पे तुम शहीद हो रहे हो, वो नहीं हो रहे। उनके बच्चे मुल्कों से बाहर पड़ रहे, तुम्हारे बच्चे बर्बाद होंगे।
It used to be said Pakistan is run by the 3 A's: Allah, Army and America. Today the army is at the receiving end of public anger. Imran's arrest has created history in Pakistan. Will Pakistan be freed from the shackles of its army? Bureau Report, India Today.
Weather forecast now. Delhi, maximum 40 and minimum 25 degrees. Mumbai, maximum 31 and minimum 28 degrees. Kolkata, maximum 41 and minimum 27 degrees. Bangalore, maximum 31 and minimum 24 degrees. Chennai, maximum 33 and minimum 28 degrees. Hyderabad, maximum 38 and minimum 26 degrees.
Make your media plan smarter with India Today Live TV on your connected devices. Amplify your brand with 100 million smart internet viewers. To advertise, mail us at sales@ajtak.com.
Why does this happen? Let me tell you the science behind it.
For more informative videos like this, keep watching India Today News Mo.
Weather forecast now. Delhi, maximum 40 and minimum 25 degrees. Mumbai, maximum 31 and minimum 28 degrees. Kolkata, maximum 41 and minimum 27 degrees. Bangalore, maximum 31 and minimum 24 degrees. Chennai, maximum 33 and minimum 28 degrees. Hyderabad, maximum 38 and minimum 26 degrees.
powered by
The world comes together at Sharda University.
Good afternoon. You're watching Lunch Break here on India Today. I'm Akshita Nandagopal, getting you all the updates on two big stories coming in from the Supreme Court. One on the Mahasena battle and the other on the Delhi dangle between the government and the centre. We'll get to the latest on the takeaways from the two verdicts. The headlines first. Moral win for Uddhav, but relief for Shinde in top court. Eknath Shinde stays as Maharashtra Chief Minister. Supreme Court says can't reinstate Uddhav because he voluntarily quit as the Chief Minister. Big win for Kejriwal government against centre. Supreme Court rules in favour of the Delhi government. Says that Kejriwal government has control over services, land, police and law and order with the centre. Big fallout of audio tape leak by BJP. Stalin strips Parnivel Tyagarajan of the Finance Ministry. PTR shunted out, now is the IT Minister. China shields terror in UN once again. Stonewalls India's proposal to tame Jaish. Objects to blacklisting Masood Azhar's brother Abdul Azhar. Pakistan descends into total chaos after 8-day custody of Imran. Protesters torch Jinnah House, attack Pakistan Army base in Abbottabad. Reactions coming in on the Supreme Court verdict on the Mahasena battle after Uddhav Thackeray. Aditya Thackeray has now reacted, slamming Eknath Shinde and slamming the Shinde government. Aditya has highlighted what the Supreme Court has said to call all that's happened and the current government is unconstitutional, illegal and immoral. He's fired a Gaddar Sarkar jibe at Chief Minister Shinde. So Aditya Thackeray also lashing out at the Shinde government. This comes after the Supreme Court had questioned the manner in which everything played out in Maharashtra, including how the Shinde government was formed, how Eknath Shinde was made the Chief Minister, but at the same time refused to intervene, saying very clearly that Uddhav Thackeray, if he had faced a floor test, then maybe we could have intervened, but considering he had resigned voluntarily, there is nothing that we can do. And now Aditya Thackeray has highlighted this to say that clearly this is a Sarkar that's unconstitutional, illegal and immoral. So these are the reactions that are coming in. Just a few moments ago, you had Uddhav Thackeray also reacting, lashing out at Eknath Shinde and the government, calling it an undemocratic government that's been formed in the state of Maharashtra. And now Aditya Thackeray also lashing out, saying that clearly this government was formed in an unconstitutional manner. But whatever said and done, Uddhav Thackeray and the Uddhav Sena hasn't received any relief from the Supreme Court. While they wanted the Supreme Court to recognize what's happened and to recognize Uddhav Thackeray as truly the leader, Supreme Court has very clearly said we cannot intervene considering Uddhav had voluntarily resigned. Anisha Mathur is joining us with more details on this to give us some of the takeaways of what really the Supreme Court said. As expected, Anisha, a lot of political reactions that are coming in, with Aditya Thackeray being the latest to say that clearly this government, the Shinde government, was formed in an unconstitutional manner. So while, the Uddhav Thackeray faction has pockets to pick out of from the Supreme Court verdict to lash out at the government, at the end of the day, they have no victory really.
Well, that is very correct. And we've just been speaking to Senior Advocate Mahesh Jethmalani, who said exactly what you said. Uddhav Thackeray faction has gained a huge win as far as the moral victory, the questions of law and the legal points with regard to the powers of the governor and of the speaker are concerned. But at the end of the day, the Supreme Court has very clearly noted that Mr. Thackeray had resigned of his own free will, that there is no clock to turn back because the court cannot undo a voluntary resignation. The court also noted that the governor was in fact justified in inviting Mr. Eknath Shinde to form the government because the largest party, which was the BJP at the time, the party with the largest numbers in the House, had extended letter of support to Mr. Eknath Shinde at the time. What is going to be very crucial to see here now is how this will impact the politics in Maharashtra, because legally, while the governor has been wrapped for going beyond his powers, while the speaker has been wrapped for going beyond his power, ultimately what the court has said is that there is very little that can be done because the situation as it existed at that point of time was changed by Mr. Uddhav Thackeray because of his resignation. But clearly this verdict is going to have a huge impact on other states other than Maharashtra, where a similar dispute between a political party, within a political party may occur, because the court has very clearly drawn a distinction between splits and factions within a party and what can happen as far as recognizing a split within the party versus a split from the party is concerned. And that is going to be very, very crucial to see how it impacts the larger political situation in the country, because Maharashtra was not the first time and nor will it be the last time where we see MLAs sort of moving from one party to the other, where
a precedent in a sense. This becomes a precedent and perhaps will be quoted in future such hearings as well. Anisha, just stay on with me. Let me sum up for our viewers all that's happened in the Supreme Court. Essentially, the biggest takeaway from the verdict that's coming from the top court is that Uddhav Thackeray cannot be restored as the Chief Minister. And that's simply because of one move that he made, that he quit the post rather than facing a floor test and then having to step down. The top court even said that relief was due had Uddhav not resigned, had he not voluntarily resigned as Maharashtra Chief Minister, but instead faced a floor test, didn't have the numbers and then was forced to step down. In which case, the Supreme Court says we could have provided some relief. Uddhav said that this is just the beginning of his fight and that no matter what, he'll defeat the Saffron Party in this war, in a reaction soon after the Supreme Court verdict. For the BJP, for Eknath Shinde, this is a huge win. Maharashtra Deputy Chief Minister Federalism said that he's content, he's happy with the Supreme Court order and that Uddhav Sena's claims have fallen flat. The Supreme Court essentially also questioned the then Maharashtra Governor Bhagat Singh Koshyari, questioning his decision to call for a floor test based on the request of 34 MLAs of the Shinde faction. The Supreme Court said that was clearly incorrect, considering he did not have enough objective material. The Apex Court even said that the Speaker's decision to appoint Govt from the Shinde group as the whip of the Sena party was totally illegal. So they say that yes, the Speaker didn't act in the right manner, the Governor didn't act in the right manner, and yet despite all of this injustice, the Supreme Court can't act because Uddhav voluntarily resigned.
इथे त्यांचा येण्याचा हेतू हा आपल्याला सगळ्यांना कळला असेल. देशामध्ये एकूणच लोकशाहीची हत्या होते की काय असं चित्र दिसतंय आणि लोकशाही वाचवण्यासाठी सर्वच, नुसते मी विरोधी हा शब्द नाही वापरणार, तर विरोधी कोणाचे विरोधी, तर जे लोकशाहीची हत्या करू इच्छितात त्यांचे विरोधी असे सगळे देशप्रेमी पक्ष आणि जनता एकत्र करण्याचे जे आमचे प्रयत्न सुरू आहेत ते प्रयत्न आणखीन बळकट करण्यासाठी नितीशजी आणि तेजस्वी.
So that was a reaction from Uddhav Thackeray. What does the other side have to say? Devendra Fadnavis, Eknath Shinde getting ready there for press briefing. You can see that they're all smiles because for them this is a huge victory that's coming from the Supreme Court, away from really what the observations were. At the end of the day, the verdict has come in their favor. That's Color Cross Live.
नाही, काही लोक हरल्याबद्दल फटाके फोडायला लागलेत.
सर्वोच्च न्यायालयाने पूर्णपणे घटनात्मक ठरवलेल्या सरकारच्या पत्रकार परिषदेमध्ये मी आपल्या सर्वांचं स्वागत करतो.
I welcome you all to this press conference.
सर्वोच्च न्यायालयाने महाराष्ट्राच्या संदर्भात आज जो निकाल दिलेला आहे
The verdict given by the Supreme Court today in the context of Maharashtra.
आम्ही पूर्ण समाधान व्यक्त करतो.
We express full satisfaction with that verdict.
निश्चितपणे गिरीभाऊ या लोकशाहीमध्ये लोकशाहीचा आणि लोकमताचा आज पूर्णपणे विजय झालेला आहे.
This is a victory for democracy and for the people's mandate.
मी नमूद करू इच्छितो. हा जो काही निकाल आहे त्यातले 4-5 जे महत्वाचे मुद्दे आहेत त्या मुद्द्यांकडे मी आपलं लक्ष वेधू इच्छितो.
I want to draw your attention to 4 to 5 takeaways from this verdict.
सर्वात पहिल्यांदा तर महाविकास आघाडीच्या मनसुब्यावर पूर्णपणे पाणी फेरत सर्वोच्च न्यायालयाने स्पष्टपणे सांगितलेलं आहे की स्टेटस को एंटे करता येणार नाही. उद्धव ठाकरेंना
Supreme Court has said we cannot establish status quo ante.
दुसरं त्यांनी अतिशय स्पष्टपणे हे सांगितलेलं आहे
In clear terms, Supreme Court has said
डिस्क्वालिफिकेशनच्या ज्या पिटिशन्स आहेत
the disqualification petition,
सगळा अधिकार
the entire authority in that matter is with the
आणि
Speaker.
त्यामुळे स्पीकर हे डिस्क्वालिफिकेशनच्या पिटिशनवर सुनावणी घेतील आणि त्यात त्यांनी जे ऑब्झर्वेशन केलं ते अत्यंत महत्वाचं आहे.
Will decide on the disqualification petition.
In the instant case that warrant the exercise of jurisdiction by this court to adjudicate disqualification petition, the speaker must decide the disqualification petition. त्यामुळे याच्यामध्ये कुठलाही एक्स्ट्रॉर्डिनरी सिच्युएशन नाही. त्यामुळे सुप्रीम कोर्टाने याच्यामध्ये
This is no extraordinary situation.
आणि ते स्पीकरचे अधिकार हे स्पीकरलाच दिलेले आहेत. दुसरं
Speaker's authority remains.
सुरू असताना ज्यांच्या विरुद्ध पिटिशन सुरू आहेत अशा आमदारांचे सगळे अधिकार हे पूर्णपणे त्यांना आहेत असं देखील अतिशय स्पष्टपणे म्हटलेलं आहे. किंवा त्यांना राईट टू पार्टिसिपेट इन हाऊस रिगार्डलेस ऑफ पेंडन्सी ऑफ एनी पिटिशन ऑफ देअर डिस्क्वालिफिकेशन. आणि
MLA's right remain against whom disqualification proceedings were initiated.
डिस्क्वालिफिकेशनचा जो काही निकाल आहे त्याच्याशी काही संबंध राहणार नाही असं सांगितलेलं आहे. त्यामुळे ज्यांच्या विरुद्ध डिस्क्वालिफिकेशनचे पिटिशन या ठिकाणी चालू आहे त्यांना सगळे अधिकार आहेत हे सर्वोच्च न्यायालयाने सांगितलेलं आहे.
This has been made clear by the Supreme Court.
एक अजून महत्त्वाचं ऑब्झर्वेशन आहे की ज्यामध्ये त्यांनी
Another important observation.
इलेक्शन कमिशनला पूर्णपणे अधिकार आहेत हे स्पष्टपणे सांगितलेलं आहे. आणि
Election Commission has all the rights, it has said.
डिस्क्वालिफिकेशन पिटिशन प्रोसिडिंग्स इलेक्शन कमिशन स्वतंत्रपणे निर्णय हा या ठिकाणी घेऊ शकतं.
Election Commission can independently take a decision despite or regardless of disqualification proceedings.
प्रोसिडिंग्सवर जे प्रश्नचिन्ह निर्माण करण्याचा प्रयत्न उद्धव ठाकरे यांच्या गटाने केला होता तो पूर्णपणे चुकीचा आहे हे यातनं स्पष्ट झालं आहे.
It was wrong for the Aditya Thackeray faction to have raised questions over their proceedings.
The speaker and the ECI are empowered to concurrently adjudicate on the petitions before them under 10th schedule and under paragraph 15 of the symbols order respectively. आणि while adjudicating petitions under paragraph 15 of the symbols order, the ECI may apply a test that is best suited to the facts and circumstances of case before it. म्हणजे सगळे अधिकार हे इलेक्शन कमिशनचे आहेत.
All rights of election commission stay. There are no roadblocks in their way.
त्यानंतर एक अजून महत्त्वाची गोष्ट की याच्यामध्ये फॉर द पर्पज ऑफ 10th शेड्यूल पॉलिटिकल पार्टी कुठली आहे हे डिसाइड करायचे अधिकार देखील स्पीकरला देण्यात आलेले आहेत.
speaker has the right to decide who and which is the political party.
The speaker would prima facie determine who the political party is for the purpose of adjudicating disqualification petitions under paragraph 2(1) of the 10th schedule, where 2 or more factions claim to be the political party. त्यामुळे याही बाबतीत अतिशय स्पष्टपणे अधिकार हे स्पीकरला देण्यात आलेले आहेत.
Clearly, the rights have been given to the speaker. And most importantly,
in inviting Mr. Shinde to form the government, असं म्हटल्यामुळे आता हे सरकार पूर्णपणे
because the governor said, it was said that the governor was justified in calling Eknath Shinde to form government. This
मला असं वाटतं की
foundation of the government is entirely constitutional.
अर्थात ते सर्वोच्च न्यायालयाला मानत असतील तर, आम्ही तर मानतो ते मानत असतील तर त्यांच्या
if they respect the Supreme Court,
आज
hopefully they are satisfied.
उद्धव ठाकरेजींची पत्रकार परिषद मी बघितली.
I watched the press conference of Uddhav Thackeray.
थोडं शेवटचं मला पाहायला मिळालं आणि त्याच्यामुळे ते असं म्हणाले की मी नैतिकतेच्या आधारावर राजीनामा दिला.
That I resigned on the basis of morality.
जनता पक्षासोबत निवडून आलात आणि काँग्रेस राष्ट्रवादी सोबत गेला तेव्हा ही नैतिकता मध्ये बंद केली होती याचं
were elected to power in alliance with the BJP and then went with the NCP and Congress.
खरं म्हणजे
Where was the morality then?
नैतिकतेचा विषय तुम्ही सांगू नये, कारण तुम्ही खुर्ची करता विचार सोडला आणि एकनाथ शिंदेंनी विचाराकरता खुर्ची सोडली. ते सत्तेमध्ये होते आणि ते विरोधी पक्षासोबत आमच्या सोबत आले. त्यामुळे नैतिकतेचं बोलण्याची कुठलाही अधिकार, नैतिक अधिकार तुम्हाला नाही. उद्धवजी, तुमच्याकडे नंबर नाही, तुम्ही हारणार आहात, तुम्हाला सोडून गेले आहेत. त्यामुळे त्या लाजेपोटी आणि त्या भीतीपोटी तुम्ही त्या ठिकाणी राजीनामा दिला. त्यामुळे विनाकारण त्याला नैतिकतेचा मुलामा चाडवण्याचा प्रयत्न करू नका. एकनाथ शिंदेंनी राजीनामा देण्याचा प्रश्नच उद्भवत नाही, कारण आज त्यांच्या नियुक्तीवर पूर्ण शिक्कामोर्तब सर्वोच्च न्यायालयाने या ठिकाणी केलेलं आहे. मुख्यमंत्री बोलायच्या आधी मी हिंदीमध्ये फक्त थोडंसं ब्रीफिंग आपल्याला करून देतो. माननीय सुप्रीम कोर्ट ने आज महाराष्ट्र के मामले में जो डिसीजन दिया है उस पर हम पूर्ण तरीके से संतोष व्यक्त करते हैं और अब किसी को भी ये शंका नहीं होनी चाहिए कि महाराष्ट्र की सरकार पूर्णतः संवैधानिक है, पूर्णतः लीगल है और ये पूरे संवैधानिक ताकत के साथ यहां पर कार्य कर रही है. जो ऑनरेबल सुप्रीम कोर्ट ने आदेश दिए हैं उसमें से चंद मुद्दे ये मैं ऐसा मानता हूं कि बहुत महत्वपूर्ण है. पहला मुद्दा, सुप्रीम कोर्ट ने यह कहा कि स्टेटस को एंटे नहीं किया जा सकता. उद्धव ठाकरे इन्हें वापस मुख्यमंत्री नहीं बनाया जा सकता. जो उन्होंने मांग की थी उनके पिटीशन में, ये बहुत स्पष्ट रूप से उच्चतम न्यायालय ने कहा है. दूसरा, उच्चतम न्यायालय ने कहा है कि डिस्क्वालिफिकेशन पिटीशन का फैसला ये स्पीकर करेंगे, ये फैसला सुप्रीम कोर्ट नहीं करेगा. और उस पर बहुत स्पष्टता से सुप्रीम कोर्ट ने कहा है देयर आर नो एक्स्ट्रॉर्डिनरी सर्कमस्टांसेस इन द इंस्टेंट केस दैट वारंट द एक्सरसाइज ऑफ जुरिस्डिक्शन बाय दिस कोर्ट टू एडजुडिकेट डिस्क्वालिफिकेशन पिटीशन. देयर आर नो एक्स्ट्रॉर्डिनरी सर्कमस्टांसेस ऐसा कहा है. द स्पीकर मस्ट डिसाइड डिस्क्वालिफिकेशन पिटीशन. ये सीधे सीधे स्पीकर को अधिकार दिया गया. उसके साथ साथ जो विधायक जिनके खिलाफ डिस्क्वालिफिकेशन की पिटीशन दाखिल की गई है, उनके राइट टू पार्टिसिपेट इन द असेंबली या उनके कोई भी संवैधानिक अधिकार या उनका जो अधिकार है एक जनप्रतिनिधि के रूप में, ये सारा का सारा कंटिन्यू होगा। इसमें डिस्क्वालिफिकेशन पिटीशन से कोई बाधा नहीं आएगी, ऐसा भी बहुत स्पष्ट रूप से इस ऑर्डर में कहा गया है। इसके साथ साथ एक और बहुत महत्वपूर्ण चीज है जो इस ऑर्डर में कही गई है कि इलेक्शन कमीशन का जो अधिकार है, उस अधिकार को बहुत स्पष्ट रूप से कहा गया है कि वो अधिकार डिस्टिंक्ट एंड डिफरेंट फ्रॉम द प्रोसीडिंग्स ऑफ डिस्क्वालिफिकेशन इन फ्रंट ऑफ स्पीकर। इसका मतलब यह है कि स्पीकर के सामने जो भी डिस्क्वालिफिकेशन पिटीशन के प्रोसीडिंग्स चल रहे हैं उसका, क्योंकि शिवसेना ने मांग की थी कि चूंकि ये प्रोसीडिंग चल रहे हैं तो आप इलेक्शन कमीशन को रोकिए और उनको निर्णय मत लेने दीजिए, लेकिन आज सुप्रीम कोर्ट ने स्पष्ट कर दिया कि इलेक्शन कमीशन को ये पूर्ण अधिकार है। तो एक प्रकार से इलेक्शन कमीशन ने जो निर्णय श्री शिंदे जी के नेतृत्व में शिवसेना और सिंबल का किया है उसमें कोई बाधा नहीं है और वो पूरा अधिकार इलेक्शन कमीशन का है, ये स्पष्ट रूप से इसमें कहा है। इसके साथ साथ उन्होंने आगे ये भी कहा है, मैं इसको पढ़कर दिखाता हूं कि द स्पीकर एंड द ECI आर एम्पावर्ड टू कॉन्करेंटली एडजुडिकेट on the petitions before them under the 10th schedule and under paragraph 15 of the symbols order respectively. While adjudicating petitions under paragraph 15 of the symbols order, the ECI may apply a test that is best suited to the fact and circumstances of the case before it. इसका मतलब ये दोनों को बिल्कुल अलग कर दिया है। फैक्ट्स एंड सर्कमस्टांसेस पे वो निर्णय ले सकते हैं, उन्होंने निर्णय ले लिया है। अंतिम निर्णय जो भी वो लेंगे वो आपके सामने है। इसलिए मुझे ऐसा लगता है कि इस बारे में भी किसी के मन में अब कोई शंका नहीं होनी चाहिए। इसके साथ साथ स्पीकर को भी यह अधिकार दिया गया है कि 10th शेड्यूल के मायने रखते हुए पॉलिटिकल पार्टी कौन सी है इसका प्राइमा फेसी डिसीजन स्पीकर करेंगे और बहुत स्पष्ट रूप से कहा है द स्पीकर वुड प्राइमा फेसी डिटरमिन हु द पॉलिटिकल पार्टी इज फॉर द पर्पज ऑफ एडजुडिकेटिंग डिस्क्वालिफिकेशन पिटिशंस अंडर पैराग्राफ 2(1) of the 10th schedule where 2 or more factions claim to be that political party। तो स्पीकर साहब को भी अब यह अधिकार है कि दो गुटों में से पॉलिटिकल पार्टी ये कौन सी है, ये स्पीकर साहब प्राइमा फेसी पहले वो डिसाइड करेंगे, उसके बाद फिर ये डिस्क्वालिफिकेशन पिटीशंस के ऊपर आगे में डिसीजन होगा। इसके साथ साथ एक और चीज बहुत स्पष्ट रूप से सुप्रीम कोर्ट ने कही है, द गवर्नर वॉज जस्टिफाइड इन इनवाइटिंग मिस्टर शिंदे टू फॉर्म द गवर्नमेंट। इसका मतलब यह है कि सुप्रीम कोर्ट बहुत स्पष्टता से कहता है कि गवर्नर साहब ने शिंदे जी को मुख्यमंत्री पद की शपथ लेने का जो न्योता दिया वो सही है। इसका ही मतलब यह होता है कि शिंदे जी के नेतृत्व में जो सरकार तैयार हुई है वो लेजिटिमेट है, वो कॉन्स्टिट्यूशनल है और इसलिए हम सुप्रीम कोर्ट का आभार व्यक्त करते हैं। जो लोग ये कहते थे कि ये सरकार संवैधानिक नहीं है, उनको इसका जवाब मिल गया होगा, बशर्ते वो अगर सुप्रीम कोर्ट को मानते हो तो, क्योंकि कई बार सुप्रीम कोर्ट पर भी वो प्रश्न चिन्ह लगाते हैं। तो अगर देश के संविधान को और सुप्रीम कोर्ट को अगर वो मानते होंगे तो आज उनको इस बात का जवाब पूर्ण तरीके से मिल गया कि श्री एकनाथ शिंदे जी के नेतृत्व की सरकार ही संवैधानिक है, पूरे तरीके से लेजिटिमेट और लीगल सरकार ये है। आज उद्धव ठाकरे जी नीतीश कुमार जी के साथ एक पत्रकार वार्ता साझा कर रहे थे और उस वार्ता में उन्होंने ये कहा कि मैंने नैतिकता के आधार पर इस्तीफा दिया था। नैतिकता की बात करना उद्धव ठाकरे जी को शोभा नहीं देता, क्योंकि मैं उनको सवाल पूछना चाहता हूं कि बीजेपी के साथ चुनकर आए और मुख्यमंत्री की कुर्सी के लिए कांग्रेस एनसीपी के साथ आप गए, उस समय इस नैतिकता को कौन से डिब्बे में आपने बंद किया था, इसका जवाब आप दीजिए। मूल रूप से उद्धव जी, आपने नैतिकता के आधार पर इस्तीफा नहीं दिया था, आपने डर के कारण इस्तीफा दिया था, क्योंकि आप जानते थे कि आपके लोग आपको छोड़कर चले गए हैं, आप विश्वास मत प्रस्ताव नहीं जीतेंगे और एक प्रकार से हारने के बाद शर्मसार होना, इसको टालने के लिए आपने इस्तीफा दिया था। इसलिए नैतिकता की बात मत कीजिए। उन्होंने ये भी कहा कि नैतिकता के आधार पर शिंदे जी ने इस्तीफा देना चाहिए। इससे हास्यास्पद क्या हो सकता है कि जिस सरकार को सुप्रीम कोर्ट लीगल, लेजिटिमेट और कॉन्स्टिट्यूशनल ठहराता है, उस सरकार के मुखिया से वो इस्तीफा मांगते हैं। मुझे ऐसा लगता है कि उन्होंने जरूर इस निर्णय का अभ्यास करना चाहिए और उसके बाद इस प्रकार की बात कहनी चाहिए। मैं माननीय मुख्यमंत्री जी से निवेदन करता हूं कि मुख्यमंत्री जी इस प्रेस वार्ता को संबोधित करें।
आजच्या पत्रकार परिषदेमध्ये उपस्थित सर्व मान्यवर उपमुख्यमंत्री जी आहेत आणि बाकी सर्व माझे सहकारी आणि पत्रकार मित्रांनो, सगळ्यात आधी मी आपलं मनापासून स्वागत करतो आणि आजचा सुप्रीम कोर्टाचा निकाल आपल्या लोकशाहीमध्ये अपेक्षित असलेला निकाल लागल्याबद्दल मी आमच्या सगळ्यांना शुभेच्छा मलाही दिल्यात, पण तुम्हालाही देतो शुभेच्छा सगळ्यांना। खरं म्हणजे अखेर सत्याचा विजय झाला आणि सुप्रीम कोर्टामध्ये आज आपण आलेला निकाल देखील पाहिला। त्याच्यामध्ये काही कायदेशीर आणि टेक्निकल बाबींचा उल्लेख आदरणीय देवेंद्रजींनी केलेला आहे। खरं म्हणजे आज आपण जर पाहिलं तर मी जेव्हा जेव्हा आपण मला विचारत होता त्यावेळेस मी सांगत होतो की लोकशाहीमध्ये बहुमताला महत्व आहे आणि या देशामध्ये कॉन्स्टिट्यूशन आहे, कायदा आहे, नियम आहे, सगळंच आहे आणि त्याच्या बाहेर कुणालाही जाता येणार नाही। हे माझे शब्द नेहमी आपल्याला आठवत असतील। आणि आम्ही सरकार जे स्थापन केलं ते पूर्णपणे कायदेशीर चौकटीत बसून कायदेशीर सगळ्या बाबींची पूर्तता करून आम्ही सरकार स्थापन केलं आणि बहुमताचं सरकार स्थापन झालं आणि आज सुप्रीम कोर्टाने त्याच्यावर शिक्कामोर्तब केलेला आहे। आणि त्यामुळे अनेक लोक यापूर्वी घटनाबाह्य सरकार, बेकायदेशीर सरकार अशा प्रकारचं स्वतःची समाधान